better to trace out. But I want to file the fresh Vaglapnama and fresh counter.
And the petition.
So when do you want?
Next week, any day.
All right. Item?
Item 28.
Item 28 next week. Give the memos. Give the memos.
Item
Interim
57, my lord.
57 of supplementary list.
This case petitioner earlier preferred
57 of the supplementary list.
supplemental list, my lord.
Yes.
Your lordship previously directed me to file an IA in the appropriate bail application, my lord, ABL appeal number. And then I have let it come along with the ABL appeal number 922 of 2019, my lord.
Yes.
Next week, my lord, along with.
All right.
Supplementary list item number 1 for judgment.
Yes. Resultantly, the appeal fails and is therefore dismissed, but in the circumstances without any cost.
Item number 2 for judgment.
The last page again. Yeah. Please. बोलो किसका appeal कर लोगे? For the foregoing reasons, therefore, the writ application is partly allowed. The opposite party authorities are directed to issue necessary orders to count the past services rendered by the petitioner from 23/2/2000 to 18/3/2010 for the purposes of pension. It is made clear that the petitioner shall not be entitled to any other service or financial benefits for the said period. Necessary orders in this regard shall be passed by the opposite party authorities within 2 months from today under intimation to the petitioner.
Item number 3 for judgment.
Therefore, taking a larger view in the matter, this court, while not being inclined to grant the main relief claimed in the writ petition, does nevertheless leave it open to the concerned authorities to consider the case of the petitioner for engagement as Anganwadi worker for the center in question by relaxing the norms and the age requirement, as has been done in the case of Anganwadi helper of the same center. The writ application is disposed of in terms of the observations as above.
Item number 4 for judgment.
In the result, the writ petition being devoid of merit is therefore dismissed. There shall be no order as to costs.
Item number 6 for judgment.
In the result, the appeal succeeds and is therefore allowed. The impugned judgment passed by the first appellate court is hereby set aside, and the judgment passed by the trial court is confirmed.
Item number 6 for judgment.
In the result, the appeal succeeds and is therefore allowed. The impugned judgment passed by the first appellate court is hereby set aside. The matter is remitted to the first appellate court to consider the appeal afresh after allowing the petition dated 15/3/2024 filed by the defendant appellants for adducing additional evidence, giving due opportunity to the plaintiff respondent to adduce rebuttal evidence, if any. The appeal shall be disposed of within 3 months from today.
Item number 7, fresh admission.
Pass out. Pass out.
Item number 8.
May I please? That the petitioner take the last prayer for transfer of the criminal proceeding initiated by the opposite party from Jagshinghpur to Kendrapada.
Yes.
But a CPU was preferred by the present petitioner. In that case, the opposite party appeared at filed his objection, and the petitioners filed this as because his old parents are bedridden, and the house of the opposite party is nearer to Kendrapada than Jagshinghpur. Then as because he appeared in that case and it will be convenient, there is no harm subject to her. It may be transferred to
No. 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 Jacobi. Considering this is an application for transfer of TRPCRL number 35 of, you see criminal proceeding number 35 of 2024, pending before the learned judge family court Jagshinghpur to the learned judge family court Kendrapada. Therefore, transfer has been made on the ground that the petitioner has old and ailing parents, which will old and ailing parents to attend to. As such, it will be difficult on his part to proceed to Jawasinghpur to attend the court on the date of posting of the case. It appears that the case in question has been filed by the wife of the petitioner, who is a resident of the district of Jawasinghpur. Stop. If the case is transferred, it would definitely cause inconvenience to the opposite party wife. She being a lady. So under such circumstances, I am not inclined to entertain this application. I am not inclined to consider the prayer for transfer favorably. The transfer application is therefore dismissed. Yes.
I may be allowed to.
Yes, it goes without saying that it shall be open to the petitioner to appear through virtual mode by seeking necessary permission of the court below.
Item 9.
May I please? My lord, the opposite party instituted one civil suit before the civil judge senior division Bhanjanagar. And that petition number 1 and petition number 2 and 3. The brief fact is that petition number husband, who is the Shivram Behera, executed one agreement in 2018 for selling a portion of the house. Afterwards, he has expired in 2022. Before expiry, there's an opposite party, Susanti Sahu. He has a possession of the house, portion of the house. And after expiry, that he has requested to this petitioner to execute the sale deed after paying 40,000.
No, why do you want it to be transferred?
Because that petition number were after expiry of the Shivram Behera, she is residing at Kanswal in Raurkela. And petition number 3, she is residing in Raigada after marriage, after her marriage. So this case is pending before the Bhanjanagar, coming to and fro journey and expensive and every chance of the threatening. So
You want it to be transferred to Berhampur,
Berhampur,
but you are yourself staying at Sundargarh.
because that council,
Hey, take a request for it.
council for the petition number petitioners appearing, those are practicing at Berhampur, and they are getting information from Bhanjanagar difficulties they're facing.
All right, take notice. Issue notice to the opposite party by registered post, by speed post, fixing a short returnable date. Requisites be filed within 3 working days. List this matter
8th November.
on 8th November.
Item number 10.
May I please, lords. Petitioner seeking transfer of the safety Miller from the learned judge family court Jaspur to learned judge family court Dhenkanal Miller. But the opposite party, being the husband, filed a CP for divorce Miller, and the petitioner residing at Dhenkanal at her paternal house Miller. And last week Miller, my lord has pleased to in a TRPCRL issue notice to the opposite party Miller. Same matter between the same parties Miller. The grounds Miller in the present case seeking transfer.
No, that is relating to the same case.
No, between same parties.
Another case.
Another case, 125 case Miller.
All right, take notice. Notice, stay.
Grateful. Miller.
Koi tarikh?
8th November.
8th November. Yes.
Item 11.
May I please,
Urgent certified copy. Pardon.
Urgent copy.
May I please, Your Lordship. My lord, the petitioner challenged the impugned order under Annexure 9, page 31. My lord, earlier, the petitioner has approached your lordship and the petitioner report directed to consider the representation of the petitioner.
So what is your basic grievance? What is your grievance?
My lord, the petitioner was initially engaged as Anganwadi worker of Morad Anganwadi Center by the Annexure 3 on 1/9/2018. He was continued till 17/1/2022 when his engagement was cancelled pursuant to the order passed in a residential certificate appeal by the sub-collector ex parte. Against that order, the petitioner has approached this honorable court, and this honorable court set aside the cancellation of residential certificate and remanded the back. Thereafter, the petitioner has approached several times, but not yet re-engaged. Lastly, your lordship directed to consider the representation of the petitioner for re-engagement by the CDPO. Now the committee headed by the sub-collector rejected the grievance and directed for fresh selection, my lord. And
On what ground? On what ground?
on the, my lord, the entire action of the sub-collector is arbitrary.
No, on what ground it was cancelled?
Cancelled, my lord. Now they does not want the petitioner to be engaged as
No, what ground they have taken in the impute
Ground-
order, sir?
the ground taken that now in the meantime the qualification fixed for +2 and the petitioner is at 10th pass. But he was at that time when she was engaged, the qualification was a 10th pass.
So where is the order passed by this court?
My lord,
Setting aside the order of disengagement? No. There's no such order.
No.
cancellation of residential certificate, order annexed 5, my lord. This honorable court set
Let us see
aside
the disengagement order. ଏ ତ ଦ୍ୱାରା ଆପଣଙ୍କୁ ଜଣାଇ ଦିଆଯାଉଛି as per appeal case number ଏତ sub collector additional ଆପଣଙ୍କୁ ଦିଆଯାଇଥିବା cancel କରାଗଲା ଏବଂ ଆପଣଙ୍କୁ କାର୍ଯ୍ୟରୁ ବହିର୍ଭୂତ କରାଗଲା. So basing on that order passing that appeal case,
Yes.
she was disengaged. Now that appeal case order was set aside.
Set aside.
Where is that order?
The annexed 5, my lord, page 21.
Matter is remanded to the sub
Remanded
collector.
to the sub-collector.
So what did the sub collector do?
Not yet any decision taken.
No decision has been
No
taken.
decision has been taken. Even the impugned order has not dealt with that fact.
What is this order again?
Again, my lord, annexure 9.
But the appeal, no, this is annexure 7.
Annexure 7, my lord,
After
earlier
getting
the
the order
honorable,
was appeal was
directed to
not
consider the representation.
Let us read this order. The
Fine.
petition is agreed by issuance of order dated of the CDPO. The sub-collector has not taken a decision as yet, as per the earlier direction.
As per the information provided by the petitioner, my lord.
But that relates to the
Cancellation of the residential certificate.
residential certificate. So,
My lord, he is also not remedialist, my lord. He can also file a content petition there. Because the order has not been complied. But when your lordship issued a direction to consider the representation with respect to the re-engagement of the petitioner, then a decision was taken after giving a chance.
no,
of
but
hearing
be that as it may, the fact remains that the entire disengagement thing was done because of the cancellation
on
of
the
the
basis of the
certificate.
cancellation.
Now that order cannot be said to be final, so to have attained finality, because the order cancelling the residential certificate now, as it stands now, has been set aside.
Yes, ma'am.
And another opportunity has been given to the petitioner
So-
to, so no final order has been passed as yet.
No.
Till such time
I,
that
I
they
do,
should.
I do not have any update instruction with respect to the finalization of that particular proceeding before the sub-collector, my lord.
So, so this court, what now I remember, what this court wanted is that you have to keep the proceeding in abeyance. That is why liberty was granted that you must approach the CDPO. So that you must keep the proceeding in abeyance till disposal of the appeal by the sub-collector. No, since this order has been passed, this impute order has been passed, remitting the matter back again,
No,
we'll have no.
No, madam.
Rather, you obtain instruction.
Immediately.
Land State Council shall obtain instructions as to the status of the appeal remanded to the sub-collector for disposal afresh as per order dated 29. It is 29, no 22/9/2021. passed by this court in WPC number 27276 of 2021. Lists this matter on
7 September, sir.
27th September. In the meantime, what is the order here?
Order my
Here,
to go
here
to
we have
press advertisement.
Fresh advertisement.
rejected the representation and a decision has been taken to issue the fresh advertisement. Till then, my lord, your lordship.
So I'll say no advertisement shall be issued, if not already issued till the next day.
Right.
IR Lakhantu. Considering the nature of the dispute, it is directed that no fresh advertisement shall be issued for engagement of Anganwadi worker of Morada, MARADA, Anganwadi Center, comma, if not already issued till the next date.
I don't know, 12.
This is with regard to the appointment of accountant from data entry operator Miller. This is covered by my lord's judgment Miller. My lord's order is there. I was disengaged.
No, this is not covered, my. May I be permitted to? My lord, Ashish Ranjan Dutta case, my lord, that whether during the pendency of a vigilance inquiry, whether a person's case can be considered because it is a case of absorption. Here in this case, my lord, what I found that previously this petitioner was before a lordship and he succeeded in that petition. And complying the said direction, he has been reinstated in the meantime. That is at Annexure 6, my lord. So with respect to the period of interruption, my lord, I didn't find any response to that one, my lord, in the final order or anything else. Now, a fresh joining report has been submitted by the petitioner under Annexure 7. So he means that, my lord, he should be absorbed.
It says the court is inclined to allow the petitioner to continue as such.
Yes.
Under the close observation of so and so, he has been warned and all that.
So, my lord, this is the direction complying your
So
lordship.
it is not even a case of reinstatement, it is a simple case of continuance, as if that order never existed.
My lord. So, my lord, this Annexure 7, 6 and 7, these are the acceptance of the petitioner, my lord, after the order of your lordships. A detailed speaking order has been passed on 14/12/2022.
Yes.
So now, taking into consideration all these aspects,
Yes.
he wants that, my lord, since persons junior to the petitioner, they have got the benefit of the absorption as the accountant cum data entry operator, the petitioner also may be. So, my lord, this case is purely on a
Premature.
different fact in comparison
No,
to
but
Ashish
he can
Mandetta.
always approach the collector citing the decision of
That is what, my lord, I'm
Ashish
submitting,
Devata.
subject to.
The same case, in my case also, is decided by your lordship, he was also party to this. Illegality.
It I would have said.
ଆଉ ତମେ ସେଟା ନ ଦେଖିକି ଖାଲି ଆଗୁଆ
Sir, mତେ copy ନ ଦେଲେ ମୁଁ କେମିତି ଜାଣିବି?
ମୋର କିଛି ଇଏ disengage ହେଇଥିଲା ଥିଲ
ଆରେ ମୁଁ ଜାଣି ମନା କରୁଛି sir.
disengage ହେଇଥିଲା ସେମ୍ ଜିନିଷ ସେମ୍ connection କରୁଛ
Go through this.
Yes.
Same, yes. They did.
Yes, sir.
Same.
Yes.
In this line.
All right. The petitioner was working as Gram Rozgar Sevak in Nuaga GP under Chandipada block of Hon'Ble district. Because of certain complaints leveled against him, he was disengaged on, where is that order of disengagement? Yes, when is that order of disengagement?
Page number my lord.
Upon data कहबे ना मते पेज कहबे मु खोजिबि देबु अरे प्रिपेयर करना दे बोटे
31/1/22
on 31/1/2022 he challenged the you had come to this court no
Yes, my
he had challenged the order of disengagement by filing a writ application being WPC number 8310 of 2022 by order dated 4/4/2022 a coordinate bench of this court set aside the order of disengagement and directed the collector to consider the matter afresh. So, pursuant to such order of this court, the collector, in his by order dated 14/12/2022, after hearing the petitioner and all concerned, found that the charges are not conclusive in the absence of sufficient supporting documentary evidence. The charges look like the charges against the petitioner. Accordingly, it was held that accordingly the petitioner was allowed to continue as such. Stop. According to Sri Mahanti, learned counsel for the petitioner, the order of this court coupled with the order of the collector implies that the petitioner was all through in service. Stop. In the meantime, he has completed more than 16 years of service as GRS. Stop. It is his further grievance that as per order dated 21/6/2024 passed by the Zilla Parishad Hon'Ble, several similarly placed GRS have been absorbed as accountant cum DEO on regular basis as per the provisions of Odisha accountant cum data entry operator
Annexure 2.
bracket method of recruitment and conditions of service rules 2024. Stop. Learned State Council fairly submits that in view of setting aside of the order of disengagement passed by this court and the order passed by the collector treating the petitioner as continuing in service, it cannot be denied that the petitioner has rendered the required length of service for absorption, that is 5 years. So, having considered the submissions, having considered the facts of the case and the submissions as above, this court finds considerable force in the submission of Sri Mahanti and counsel for the petitioner. Sri Mahanti the writ application is therefore disposed of, directing the collector Hon'Ble to consider the case of the petitioner for absorption, taking note of the observations made in this order. Stop. A decision in this regard shall be taken within 4 weeks from the date of production of certified copy of this order by the petitioner. Yes.
Urgent.
Second time saying.
No, second টা deeper.
देखिए second one with execute asking. Urgent certificate copy.
Prayer is identical. Fact little bit different.
What is the difficulty?
Well, page 21 may be seen. The period of engagement is same and disengagement is same.
No, but I may be permitted to take
Yeah.
your lordship to the previous order of this honorable court.
Where is it?
This, well, that is at Annexure 6. It is at page note 28. There
No,
the
Annexure 5 is that order of in the previous writ application.
Annexure. Yes, ma'am.
It offers the opposite party to.
Yes, madam.
There.
There, madam, para number 7. without interfering with the
So
order.
the order was not set aside.
No.
But what did the collector do?
Thereafter, my lord, the annexure 6, my lord.
The case record and the report of the video which exonerates the GRS of Gala. Maybe reinstated on reinstated same hello. Same hello.
With a further rider, my lord, that
Fresh
is not be
agreement.
entitled to the any wages and incentive for the we did not work.
Wages no.
So, my lord, my submission, my submission, my lord, that other than little bit of factual difference, what your lordship now just now dictated, prayer is same, and the order may be
No,
same.
different
but
order
only the factual difference is only this much.
So the order will be a little bit different.
Yes,
I'll
that is what
I'll
I
let
am
him-
submitting. not
all right, I'm
to
passing
the-
that order. I will pass that order. The petitioner was working as GRS, Gram Producer Sevak, in Kusokila Gram Panchayat. Who jaga? Chandipada block of Hon'Ble district. Since
12/11/2007.
12/11/2007. So, because of certain allegations leveled against him, he was disengaged by order dated.
My lord, that is
From 25/1/2022.
yes.
By order dated 26/2022.
ठीक next purchase
25/1/2022.
कोई जगह अच्छी
Sir, the previous order of the honorable court.
अच्छा 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 26/2022
is reflected.
he
Next one.
challenged such order before this court in WPC number 8455 of 2022. By order dated 23/8/2023, this court directed the petitioner to approach the collector by submitting a fresh representation. Pursuant to such order, a representation was submitted, which was heard and disposed of by the collector by order dated 8/2/2024, directing reinstatement of the petitioner, but without any back wages. Stop. It is the further grievance of the petitioner that by order dated 21/6/2024, passed by the Jilla Parishad Hon'Ble, several persons have been absorbed as the accountant cum data entry operator on regular basis as per the provisions of such and such rules. See rule type जो लिखा है. Stop. Srimati submits that the petitioner having been reinstated in service must be treated as
Eligible.
no, must be having been reinstated in service must be treated as completed. कितने total years? 17 years of continuous service, and as such, he is eligible to be considered for absorption in the regular cadre. In the regular post कर दूँ, ले, अब last जो वो रोटा इसे कर दो,
Urgent.
urgent copy.
I don't know, 13.
Please, your lordships, my lords. Matter relates to the appointment to the post of Sikhya Sahayaka, my lords. This is in fact the second journey of the petitioner before my lords, my lords. The earlier writ petition, my lords, were disposed of by your lordships, my lords, by way of a detailed order, which your lordships will find at annexure 8 to my writ application, my lords. Only the operative portion, my lords, by way of a detailed order, my lords, your lordships ultimately directed the present opposite party number 2 to consider the representation of the
Just-
petitioner, my lords, dated 4/4/2016.
Got to it, got to it. গোল্ড বুলারে ভুল হয়েছিল এবার কোন বর্তমানে রিজেক্ট করে দিয়েছেন
সেটা রিজেক্ট করে দিয়েছেন my lords that impugned order is at annexure my lords 9 and if your lordship sees page number 79 that the ground of rejection is that my lords they had already rejected it on 31/8/2016 but interestingly my lords in the earlier writ petition my lords a counter affidavit was filed by the same opposite party number 2 on 12th of April this year 2024 wherein this fact was never mentioned my lords neither that order of 31/8
anyway this court passed an order after 2016 so that order has got no meaning once this court has passed an order you have to act upon सीधा कदम रिमाइंड करी पठेई जी कंसीडर करो एत कथा नहीं the petitioner had earlier approached this court in WPC number 19088 of 2016 with the following prayer see year कोटा कर दो इधर अच्छी है ना by order dated 25/4/2024 this court directed the district welfare officer Malkangiri to take a decision on the representation dated 4/4/2016 submitted by the petitioner. No, I think you're right. Kindly, if not already disposed of in accordance with law,
that was there but
I cannot pass this order. Since I've said that if not already disposed of and now they come up with a saying that it has already been disposed of. So we'll have to consider it on merits. We'll have to consider it on merit. So
I'll file an affidavit.
you can file, but what can you do? No reason has been given. We have to fall back upon that 31/8/2016.
Yes.
Isn't it? So what to do?
So, my lord, I may take the instruction in this regard so that your lordship may pass the final order.
No, because what has happened is, you see, why this order was passed. As he has pointed out rightly, the fact of rejection of the earlier representation on 31/8/2016 was never brought to the notice of this court in the earlier in the counter file in the earlier application. So naturally, this court therefore said that if not already disposed of, it may be disposed of. Now you say that it has been.
I'll get that, my lord.
your lordships has also directed my lords
You do one thing.
yes
You file the counter affidavit. That is what. Yes.
Counter
सभा कर दो
affidavit, yes,
जीवन
I've
तो।
annexed it, my lords annexure 10
Yeah, I've seen it. You file your, he has enclosed a copy of your counter. So if you go through the counter and what he says, without reading it, if I even accepting what he says on face value, if there is no, if you have never brought it to the notice of the court and the court passed an order,
What I
Page-
beg
page
to
83.
submit, my lord.
Hmm.
2 weeks time may be given to me to get the instruction. So that dealing with all the points, your lordship may pass up to it.
final order कर दो।
Because instead of remitting,
No, I will remitting करूँ। I will remit करूँ। Now that I found that I have said that if not already disposed of,
Yes, sir.
so they cannot be blamed for referring to the earlier order.
Yes.
They will always say that this court had asked us to dispose of, if not already disposed of. But if it has been already disposed of.
my lords my stand is my lords that order my lords if at all even if it was passed my lords it was never communicated I've taken a
That is true, that is true.
yes
That is why you have enclosed the counter.
Yes.
All right. Then State Council shall take instructions. With regard to the amendments made in the writ application. 2 weeks time is allowed for the purpose. List this matter on
27th.
on 27th.
Yes.
27th. No, 27th September.
27th.
कौन आइए?
my lords I my lords one post may be kept vacant my lords
Yes.
I'm yes
One post of कौन? Sikha Sahayaka.
in the post in the category of TGT language
In the category of TGT language shall be kept. Of which district?
in the district of Malkangiri
In the district of Malkangiri shall be kept vacant till the next date.
I'm so grateful
Item number 14.
Please, your lordship. In the year 2012, sorry, my lords, in the year 2012, I was selected as Sikha Sahayaka, to be appointed as Sikha Sahayaka. But because of some wrong calculation concerning this reservation, I could not be appointed. That is what I have come before the Honorable Court. Honorable Court, my lord, dispose of the petition, my lords, with the direction to appoint me. That was disposed upon 18/11/19. It was not complied with, I filed contempt.
then second contempt. Then tendency of the contempt now.
Second contempt ଟା କୋଉଠି ଅଛି ଗୋଟେ ଦେଖିବେ
ନାହିଁ। ଯାହା ଚାଲିଛି ଆଉ।
ମୁଁ ତଳ କୋର୍ଟରୁ ଆସିଛି ଆଜ୍ଞା ମୁଁ ଜାଣିନି ସେଥିପାଇଁ ପଚାରୁଛି ଆପଣ
Humility matters, I also.
I am also pura absolutely humble. You won't find a more humble person than me.
That is also correct.
You know me, Mr. Mahapatra.
Nah, that's
We know each other very well.
That's correct.
So I just, with utmost humility at my disposal, and I may ask.
You humility, my humble submission, I am constrained not to submit anything.
Second contempt. ମୁଁ ଆଜି ପର୍ଯ୍ୟନ୍ତ ବୁଝିପାରିନି।
Anyway, matters that now the government wanted to comply.
So what has happened is the government officer says, don't worry. ପ୍ରଥମ contempt ହେଲେ don't worry. ସେ ଆଉ ଦିଟା ଆସିବେ ତାପରେ ଦେଖିବା।
Then what happened, matters? Kindly have a glance to Annexure 1. Page 13, matters.
This is of 2024.
2024. 19 matters that was disposed of. 2024. Now I am 56. ଆଉ 3 ବର୍ଷ ଅଛି ଶିକ୍ଷା ସହାୟକ କାମ କରିବି।
No, but this order was direction to comply with the order. I
Complied
mean,
with
they have, yes.
It has been complied with. Comply କରି କଣ କଲେ ମତେ ଆପଣ ଟିକେ ଦେଖନ୍ତୁ Annexure 2.
Annexure 2, yes.
Page 2, page 14. ତାଙ୍କର principle ହଉଛି they will offer option in respect of that particular block 3 schools, primary schools. Options were called for. Options have come. I was required to give option. I have given that option in Annexure 3. Out of the 3 months in my Mahanga block, I belong to Mahanga block. Now what happened? Intentionally, deliberately, because I filed content and all these things, I was pushed and shunted into Nishchit, last part of the Nishchit Koil block. In a Urdu primary school, I was appointed as a Shiksha Sahak at a paltry amount of 11,000 rupees. I'm all along to move 35 kilometers every day. In spite of months of that option sought for, option exercised. Any of the 3 schools, I said option number 1. You may opt to, you require that option from the DO.
Yes, later you obtain instruction.
Or else, my lord, Annexure 6 representations are pending before the authorities.
That order matters that Annexure 4.
No, Annexure 6, Apika, why don't you obtain, I'll ask you to obtain specific instructions if he can be adjusted in
Yes, ma'am.
any of the 3
I'll-
schools for which he had given an option. You call for option from him and then you post him somewhere else. Now, what is the meaning of calling for option? Yes. Then State Council shall take instructions if the petitioner can be adjusted in any of the 3 schools opted by him under Annexure 3. And further, the reason for posting him in the school, in school, कौन सी जगह था? In which school?
Nishchit Koil block ro school नाम टा हला Nagaspur Urdu Government Primary School.
Nagaspur Urdu Government Primary School at Nishchint Koili. Is this matter on 4th October? Before vacation, I think you just obtain the instruction. If necessary, we'll like to. You have to find out whether there are any vacancies.
କେବଳ ଯଦି ସେତିକି 27th ରେ ତ
27th.
October.
ସେଠି ଖାଲି ଦେଖିବା କଥା vacancy ଯଦି ଅଛି ସେ ଦେଇଦେଲା ଯିବ ତାକୁ option ମାଗିଥିଲେ ସେ option ଦେଇଛନ୍ତି ସେ ରଖ କଣ ସରିଲା।
ଯଦି ବି ହେଇଯାଇଥିବ ତାହେଲେ ଇନଫ୍ରାଷ୍ଟ୍ରକ୍ଚର
The instruction.
ଦେଖो
Small prayer matters. Annexure 4, they say that you join by 9th. Means Nagaspur is far distance place.
now so what you join but
yes
you join.
with a rider, my lord, his joining will not
Yes, yes.
prejudice.
I agree. In case if the petitioner
May not pass any order matters that may be there. I will pursue him to
All
go
right,
and join there. That will be better.
it will be better
Any observation?
because otherwise what will happen once you do not join, then there could be some legal complications. You just join because they'll say that you have not complied with our.
I will pursue that because what is happening is that whole total area dominated by the Muslim people. You will have having a house there. Now you have to go all out from that particular place to 35 kilometers.
No, but in Urdu school, why will this person be? How can he on your subject so much?
Thing is that once I become annoyed, I can do what not.
All right.
And that is what I filed contempt twice.
But staying it will not be not inure to your. That will amount to stay.
Staying that no, some may not be given effect.
से हेलानी से कथा हेलानी.
Oh, that ठीक है था उसे ठीक है था.
Yes.
27th of
This month.
ଆଉ 3 ବର୍ଷ ତାଙ୍କର ଅଛି ଆଉ
देखिए.
even regular ବି ହେଇପାରିବ.
Item number 15.
In my lords, the petitioner is working as GRS for 16 years continuous service. My lords, at page 41. At page 41, the selection committee unanimously decided to hold up the process of absorption of the petitioner as because a locayukt case is pending against her. But my lords, at page 42, my lords, the authority has absorbed several GRS against whom
That Ashish Devata case will apply.
locayukt cases are.
Mr. Patnaik,
Yes, ma'am.
this Ashish Devata case would be applicable.
Yes, my lord.
Really?
And
And he has also relied upon this same.
my lords, that has
So let him
been
submit a let him submit a representation along with
Yes,
that Ashish Devata case.
Yes.
It will be considered.
Yes.
Because that Lokayukta is the same thing. Vigilance jai, Lokayukta se.
the
locayukt more inquiry pending
Yeah,
whether
that's all right.
case will be.
Lokayukta is basically, it's an inquiring agency.
My
It
lord.
is nothing, it's not a prosecuting
Yes,
agency. The prosecution will always take place before the appropriate court.
My lord.
The limited grievance of the petitioner is that his case for absorption as accountant cum data entry operator on regular basis has been kept in abeyance. Kahin se order tha?
At 41 page,
Has been kept in abeyance,
as per annexure 9.
has been kept in abeyance in view of the pendency of an inquiry before the before the Lokayukta, Odisha. Stop. Learned counsel for the petitioner submits that in view of the ratio decided by this court in the case of Ashish Kumar Devata so and so, the pendency of such a case is not material, is not relevant insofar as it is not a bar for consideration of the case of the petitioner for absorption to the regular post, subject to fulfillment of other eligibility conditions. Stop. Such being the facts, the writ application is disposed of, directing the petitioner to submit a representation along with copy of the judgment passed by this court in Ashish Kumar Devata Supra within 2 weeks from today. कहाँ पे गए थे? Submitted the representation to the collector. The collector को जगह?
Bhadrag.
Collector Bhadrag. Right. In 2 weeks from today. If such a representation is filed within the period stipulated, the collector shall consider the same in light of the aforementioned judgment of this court and pass appropriate orders regarding absorption of the petitioner, subject to fulfillment, subject to other eligibility conditions, subject to fulfillment of other eligibility conditions by him within 2 weeks thereafter. Stop. The collector shall act upon a certified copy of this order to be produced by the petitioner.
My lord, so apart from that, other GRSs have been absorbed. सेटा टिके जो मानको against vigilance case एवं लोकायुक्त case मु तार entire
It is also submitted that persons similarly situated as the petitioner have also been have been absorbed on regular basis. So, if such submission is found to be correct, the collector shall also take note of the same while disposing of the representation.
say decision टा टिके सेटा से hold up कोई
No, that will obviously
Yes,
that
yes.
will be considered.
Decision ta?
से जो ସେମାନେ डिसीजन नहीं जंदी यांको प्रोसेस टा को होल्ड अप कर दवा
हाँ, so collector को direction दिया गया है. Collector will consider your representation.
His candidates have not been rejected.
Yeah, yes, yes.
Yes. So now the direction is given to
The collector
Obviously,
to consider it in light of the judgment passed by this court.
Yes, ma'am.
If they don't consider you again, you get a cause of action, fresh cause of action. Yes.
Like no 16 patent matter.
On behalf of Mr. Pradeep Kumar has taken one capital. Since the mother was expired, man.
All right. Therefore, adjournment is made on behalf of Sri Pradeep Kumar Das, land counsel for the opposite parties, on the ground of, on the ground of bereavement in the family. Is this my when do you want?
One capital, man.
Is this matter on
20th September.
Kudi on 20th September? Yes.
ରିକ୍ୱେଷ୍ଟ କରିଥିଲେ ଯେ 20 ତାରିଖ ତାଙ୍କର କଣ ଯୋଉ 13 ଗଲା ପରେ କି ତା ପର ୱିକ୍ ଠାରୁ ରଖୁଛନ୍ତି
27th. 27th.
I don't know 17.
Look after vacation, so that Durga Puja after asile.
You have been taking time. First of all, you did not appear on 3 or 4 days. No. Mr. Rai, I will not grant any further time. No. Just look at the order sheet. Look at the order sheet. This is a 2013 matter. Why should I keep it pending? If you are not willing, if you have no instructions, withdraw it. I'll pass that order granting you.
Instruction is there that she has gathered some documents, but due to
No.
illness,
No, I will not grant you time.
physical handicap let him.
No, sir, I will not grant you time. No physical handicap, nothing. She has approached this court. I'm sorry, I will not grant you time.
The petition is though meritorious candidate, but in interview she has not been given a mark.
So you argue on merit, I will consider.
And
Argue it on merit. I will not grant you time. I will not grant you time, sir. This is, you have taken the care. Dekhant.
letter को ask कर मैं कौन करी मोर श्रीजर कबाग राशि मोर
छाड़ दे case 26/2/2024, 6/3/2024, 27/3/2024, 25/4/2024,
I cannot
16/5/2024,
I cannot disbelieve my lords
28/6/2024, 11/10/7/2024, 24/7/2024, 7/8/2024, 23/8/2024, 30/8/2024. On 3 consecutive dates, even though there was no appearance from your side, since it was a part-heard matter, I did not dismiss it.
expert को दादा जी नथी
हबनी मु डिसमिस करेन हबनी आज आपण आर्गु करंतु जा करंतु नॉट आई विल डिस्पोज इट ऑफ सेइंग दैट यू हैव नो इंस्ट्रक्शन इन द मैटर नो मींस नो
गणेश पूजा सला पर
किछि गणेश पूजा पूर्वरु कर दो गणेश पूजा पूर्वरु कर दो मैटर करो नॉल में सांग डिसमिस कर देबे आज्ञा
श्रीजर को गोटे पदर तो सर जो
ना श्री अजूर कर किछि हबो नै श्री अजूर को एई तो हबो एक ना
नेक्स्ट रख सर I will finish there. गोटे एफिडेविट दे देबी I will finish this.
ना आज रो गोटे मु आपन कहली करबिनी माने करबिनी nothing can change. No. Once I make up my mind, it is not possible.
Made up their my lord's mind.
No, I've not made up my mind as regards the merits of the case.
No merit.
Merit of the case, you can argue whatever comes out.
That's why.
But I will not grant you time. That I am very sure. I am willing to pass it over for some time. If you are not ready, you can argue after lunch also. But beyond that, हबो ना एते माने 10टा की 12टा डेट गलानी पास ओवर फाइल देखि दो कर दो जाथिबो तू कर दो सर दो यस
I may be pardoned, my lord, in the item 50. My lord, a post may be kept vacant.
No.
Disposal of
No.
petition.
No, sir.
My lord, I am eligible.
You are eligible, that will be considered. We do not know whether you are eligible or not. Only eligibility खाली सही ता नुए आउरी बहुत जिंस ता देर अछि. So no post will be kept vacant if you are found to be
Decision रे समाने लिखि देइ जनी clear से गुटे केवल लोकायुक्त केस also vigilance clearance report, criminal clearance report.
Sir, I have passed a very good order in your favor. Ketik नहीं जाना. Yes. कौन है लंबा ऑर्डर ऑफिसर this clear admission that in the recruitment of what happened to the vacancy of the year 2013 under the PS category of PGT Arts in the next recruitment process? Yes.
My lord, with respect to the information submitted by the DEO, your lordship took note of the same, my lord, on 16/8, 2024.
Yes.
And accordingly, a direction was issued to me to get the instruction from the Director of Secondary Education. My lord.
What have they said?
they have narrated everything, my lord, and the last para.
Last one.
That para number 8, my lord. Sorry. Para number 8. That as regard to the vacancy of one PWD OH category in TGT Arts in the year 2013 of Kendrapada district, it submitted that TGT Arts is a state cadre post, and after collection after collection of unfilled vacancies of the recruitment year 2013
collation
collection
collect କରିବା ମାନେ ମାନେ ସବୁ ଜିନିଷକୁ ମିଶେଇକି ଗୋଟେ ଇଏ କରିବାଟାକୁ collect କରିବା
କରିବା
collect ହେଲା ତ acquire କରିବା this is collect ମାନେ vacancy ଧରନ୍ତୁ କେନ୍ଦ୍ରାପଡ଼ାରେ କେତେ ଜଗତସିଂହପୁରର କେତେ ସୁନ୍ଦରଗଡ଼ର କେତେ ଏଇ ସବୁଟାକୁ ଆଣିକି ଗୋଟେ ଜାଗାରେ ରଖିବାଟାକୁ କୁହନ୍ତି collation. Yes, sorry. Collation of unfilled vacancy of the recruitment which included vacancy of PWD from all districts.
Which included vacancy of PWD category from all the districts of the state as a whole.
Ali, we were seized with this question, whether special categories can be carried forward. I don't know.
So, my lord,
It says it was carried forward.
yes,
But in the 2014 recruitment year, there is no mention of PWD candidates.
yes, ma'am.
So this is completely misleading, sir. He is passing the buck to block education officer, district education officer is passing the buck to the director. Director, in a way, has passed back the buck again. The education officer, the office of the DO had no role to play in the recruitment process for the year 2014-15.
2014-15.
So 2014, they were considered.
In 2013-14, my lord, we had it, the DO had
That's all right. That's all right. It still doesn't. You look. The directorate was considering.
Yes, ma'am.
So they took into consideration the entire state, the posts available in the entire state. They say it was carried forward, but in 2014-15, it was never there. Could carried forward.
With respect to Kendrapada district, ma'am.
Yeah, could carried forward. A state cadre post. How can you?
ସେମାନେ ଆଉ କୋଉଠି ଗୋଟେ ଦେଖେଇ ଦେଇଛ ବୋଧେ ଏଇଟା 31-8 ରେ ଆସିଛି I just passed on but for the fact I came across this one.
File an affidavit or something?
Yes, sir.
I will call it next week and I will complete it.
Yes, ma'am.
You understand the query? There was a clear vacancy in 2013.
Well,
What happened? It is not being shown in 2014. See, vanish kori.
Sorry to say, madam, this is the 4th time. Your lordship will be pleased to grant me that particular opportunity to clarify that.
Or should I allow the writ application?
This is
Straight away allow it. Straight away allow it, saying that this does not. This means that there is some hanky-panky involved. Clear case of hanky-panky. Appointment kar dicchendi.
Next week, sir, with an affidavit, madam, I will bring it.
Land State Council has obtained written instructions from the Director of Secondary Education, as contained in letter dated 31/8/2024. This court has perused the same. It is mentioned that the vacancy, unfilled vacancy of the recruitment year 2013, which included vacancy of PWD category from all the districts of the state as a whole. This is here they are trying to twist. It's very clear they are trying to twist, sir.
Now, for the first
The unfilled vacancies were carried forward to the subsequent recruitments. Stop. This instruction, on the face of it, is vague and does not at all answer the query of this court as to how how no vacancy under PH category was reflected in the next recruitment process held in the year 2014.
Yes.
And State Council requests for some time to clarify the position in this regard. Place this matter on 13th September. 13th nale kodi hobo. On 20th September. Learned counsel for both parties are requested to come ready for final disposal of this case.
A free copy maybe of this.
A free copy of this order be handed over to the State Council for compliance. But ଆପଣ ବୁଝିଲେ ତ?
No.
ସେଇଟାକୁ କେମିତି deliberately twist କରିକି ଲେଖିଛନ୍ତି?
Sir, ଏଇଟା ରହୁ କାହିଁକିନା ଆକୁ ଦେଖିକି
The written instructions be kept on record. It has been deliberately twisted. Suddenly ତାକୁ state cater କରିଦେବା ସେ ଲୋକଟା ଯୋଉ ବସିଛି ସେ ବୁଝିପାରିବନି। ଏଉଡା LLB ପାସ୍ କରିଥିବା ଲୋକଟି ସେ କୁଆଡେ ବୁଝିବ ଏତେ କଥା? नहीं ये जने कही से कथा कही जने संसारिया कोर्ट रे जने आईएएस अफसर को कंटेम्प्ट हेतिला अच्छा ये स्टेट रिट पिटिशन टा एटा
Say
तासे-
that, this is an outcome of that particular
Okay.
direction, my lord.
Okay.
So obviously, my lord, once this case will be decided, the other case will be automatically taken.
Item number 19.
छाड़ी दो तू छाड़ी दो
Matter regarding engagement of Anganwadi worker. Advertisement was issued for selection of Anganwadi worker. Petition was selected. Challenging the claim.
Last time you had filed an additional affidavit.
Yes, ma'am. I've already saw the copy of
Hmm.
respective counsel.
It shows that there was a ECC center at Mangad.
Mangad.
Mangad. So what is the case?
Yes, Lord. The petition has been selected, duly selected, as per the advertisement. Challenging the same, the opposite party number, opposite party number 5. File a writ application, that the jurisdiction could directed to file an appeal. That appeal has been filed by the opposite party number 5. Before the Law and ADM. The appeal has been dismissed and allowed in favor of the present petitioner. Thereafter, again, challenging this time, the opposite party has filed a writ application before the Honorable Court. This Honorable Court again remitted back the matter. Fresh hearing. That the order part, Annexure 8, challenge before your lordship. Running page 30 for your lordship.
Yes.
Man. I need last paragraph. Maybe Lord. Running page 35. In view of the material facts and analysis of the case and on hearing both the appellant and the respondent, this court is of the considered view that the selection committee has committed gross illegality and irregularity in not granting extra weightage of 5 marks to the appellant, present opposite party number 5, while conducting the selection of Anganwadi worker to Ektali Anganwadi Center, thereby depriving her the right to claim. Therefore, the selection and engagement of Anganwadi worker Ektali Anganwadi Center conducted on 28 2014 is hereby set aside. This court further directs to the selection committee headed by the sub-collector to conduct a fresh selection by giving extra weightage of 5 marks to the appellant, present opposite party number 5 as for a right to claim.
ये weightage कौन पे experience?
Yes, Lord. Minor.
Weightage कौन पे?
Issues worker. There is the difference. There is a difference between the two findings of both the law and ADM. Under Annexure 7, findings of the first appellate appeal. Running page 32 errors. Last paragraph, Lords. Thus, upon hearing and perusal all relevant materials, I have a reason to believe that admittedly the appellant, that the present opposite party number 5, has worked as the ECC worker for more than 7 years at village Mangad. But as per the letter number such and such, letter 16/2010 of the government in W and TD department, an ECC worker can be considered for selection of Anganwadi worker provided that she had worked as ECC worker in that particular village. Whereas in that particular village is also existing ECC center in Ektali ECC center. But the opposite party number 5
was working as a ECC worker at the Mangad, Anganwadi, Mangad village, Mangad ECC center. There are two Anganwadi centers. There was also Anganwadi center in the village Mangad and the present Anganwadi center in village Ekta. Therefore, the selection committee have selected a Jabagani Maji, the present petitioner, running page 33 orders. First line. As the Anganwadi worker for Anganwadi center situated at a village Ekta. And no supportive document could be filed by the appellant showing that she has worked as ECC worker for village Ekta, where the Anganwadi center exists. In view of the matter, I find no illegality committed by the selection committee on engagement of the Jabamani Maji present petitioner as Anganwadi worker at Ekta village center. This will be of it. And next, Annex 8, the same authority has decided that as a whole that the president opposite partner 5 as worker as ECC worker in the same village, but not in the same village. There are two ECC center, Ektali, the existing ECC center, and Mangad. Also, as per the your lordship's direction, also provided by the current state council, there are two ECC center. Your lordship clarified that. Last occasion. There are two ECC center, Mangad ECC center and Ektali ECC center. Ektali re gote Anganwadi center achi ebong Mangad re gote Anganwadi center achi. Also, the present opposite partner 5 not belongs to the service area of the present Anganwadi center. As per the advertisement under Annex 1, running page 14, your lordship can see that the condition. D.
Next, sir.
Annex 1, advertisement. Running page 14, 1-4. Annex 1, running page 14, 1 for your Anganwadi Karmi, mini Anganwadi Karmi for the Pai Abasaka Jogata.
Ektali.
Prathini Abasa Adivasi Samprada Mohila Huitive, Prathini Paragraph 3 point orders. Prathini Jo Anganwadi Kendra Nimanta Apadana Karibe. ସେ ସେହି କେନ୍ଦ୍ର ସେବା ଅଞ୍ଚଳରେ ସ୍ଥାୟୀ ବାସିନ୍ଦା ହୋଇଥିବେ ଏବଂ ଉକ୍ତ କେନ୍ଦ୍ରର ସମସ୍ତ ସେବା ପାଉଥିବେ। ଆବେଦନକାରିଣୀ ଯଦି ସହାୟିକା ହେଲ୍ପର ସଂଗଠନ ଅର୍ଗାନାଇଜର ରୂପେ ପୂର୍ବରୁ ସେହି କେନ୍ଦ୍ରରେ 5 ବର୍ଷରୁ ଉର୍ଦ୍ଧ୍ୱ କାର୍ଯ୍ୟ କରୁଥିବେ ବା କାର୍ଯ୍ୟ କରିଥାନ୍ତି ତେବେ
That is not relevant.
ଆଜ୍ଞା
How is it relevant?
my lord
How is it relevant? Helper ଟା କେମିତି relevant ହବ?
ହେଲ୍ପର ମାନେ ସେ ଅଙ୍ଗନବାଡି କର୍ମୀ
ଏଠି ଯୋଉ ଲେଖିଲେ ଆବେଦନକାରିଣୀ ଯଦି ସହାୟିକା ହେଲ୍ପର ସେ ନଟ
ଫାଷ୍ଟ ପଏଣ୍ଟ ଯେଉଁ ପ୍ରାର୍ଥିନୀ ଯେଉଁ ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ର ନିମନ୍ତେ ଆବେଦନ କରିବେ ସେହି କେନ୍ଦ୍ର ବା ସେବା ଅଞ୍ଚଳର ସ୍ଥାୟୀ ବାସିନ୍ଦା ହୋଇଥିବେ ଏବଂ ଉକ୍ତ କେନ୍ଦ୍ରରୁ ସମସ୍ତ ସେବା ପାଇବେ। Here is the case before your lordship that the opposite party number 5 belongs to the service area of Mangad. Also, the residents of Mangad, voter list and other any other under Mangad not belongs to the hectare.
Oh. Yes.
First appellate, first appeal also decided that.
All right, I've seen that. Don't repeat. Yes.
The lordship kindly see Annex 12. That is the guideline of the Women and Child Development Department. The last 3 lines, remand 3. An ECC worker can be considered for selection as Anganwadi worker, provided that she had worked as ECC worker in that particular village. My lord, the village is Ekta. Mangad is not a village, it is a hamlet and it is a Sahi. And I have also filed the supportive documents, certified copies of supportive annexed to the annexure to the counter affidavit, annexure A series, your lordship kindly see. Annexure A series, your lordship kindly see.
Guideline ta deji annexure 12. Running page 39.
Counter affidavit. ସବୁ ଜାଗାରେ ଲେଖା ହେଇଛି ଯେ ମାନଗଡ଼ ହଉଛି ଗୋଟେ ସାହି ଏବଂ that comes under ଏକତାଳି revenue village. ତେଣୁ ଏକତାଳି revenue village ଅଣ୍ଡରରେ ମାନଗଡ଼ ସାହିଟା ଆସୁଛି। ତେଣୁ ସେଇ ECC ସେଣ୍ଟରରେ ମୋର 7 ବର୍ଷର ଏକ୍ସପିରିଏନ୍ସ, it is also admitted by all of the revenue authorities. District record room or certified copy ଅଛି।
We also admitted. And
That's all.
she has
But
worked as
so
7
far
years.
as the findings of the ADM is concerned, there are 4 points have been determined for adjudication. The Lordship kindly see Annexure 8. That the Lorna ADM has determined at page 35 of Lordship kindly see. The first one is what is Annexure 8? Whether Mangod is separate revenue village or it is within the revenue village itself. It is admitted fact that the Mangod is coming under Ektali revenue village. Hence, I am entitled for Anganwadi worker. If the appellant Kadma Kandalkal has requisite experience certificate pertaining to village Ektali, it is also not disputed. It is admitted that I have secured preferential 5 marks in addition to my marks mentioned in the merit list. Therefore, I have secured more marks than the petitioner. And next point is, if Kadma Kandalkal is entitled to get extra weightage of 5 marks for experience and ECC instructor as per the government guidelines, yes, this is also not disputed. The only dispute is whether Mangod is coming under the Ektali revenue village or not. Now that is as per the certified copies, my lord, Mangod is a Sahi, hamlet and coming under the Ektali revenue village. Hence, as per the guideline under Annexure 12, I am entitled to be appointed for Anganwadi work.
Yes, state.
Well, this 25/2007 guideline was introduced, my lord. Thereafter, my lord, on 29/11/2008, the School and Mass Education Department, that is at page 64 of the book, my lord. We have referred to that, my lord.
Pass on the book. Boitam ଯାଇଥିଲା ବି ସେ ସାମାନ
That is a School Mass Education Department resolution, wherein they took a decision. My lord, the last para is important. With respect to considering the case of the retrenched ECC member, either as Ganashikyak or in other post, my lord, there they had decided their cases will be considered for the Ganashikyak in future, but at present, my lord, they took a decision to consider the cases for the engagement as Anganwadi worker. Now, say, 25/2007 day, once again, there was a correction, my lord. The necessary correction was there, and later on it has been introduced at, my lord, that some percentage of marks will be awarded to them. That is at clause number, that is clause number 3 with respect to marking, my lord, that page number 30.
Yes.
If the candidate is an ECC worker under the Sarva Shiksha Abhijan, NPEGL, then 5% mark at the rate of 5% mark per year for service rendered with a ceiling of 15 marks. So, my lord, since the decision of the authorities, what we have relied upon and we have in the counter, my lord, that it is with respect to the village. If the ECC worker is within the village, then he is to be given weightage for this additional mark as it has been defined, my lord, in the latest guideline of 2007, my lord. Then what it was in force. So taking into consideration that one, the decision has been taken. So, my lord, previously, my lord, this petition had approved before this honorable court. The opposite party has also approved before this honorable court. And taking into consideration the orders passed by this honorable court, my lord, the appeal was actually taken into consideration, and previously the order which was placed before lordship, that on previous occasion the ADM passed that order without taking into consideration the facts. And so there was a direction to consider the facts and the documents relied upon by the respective parties, and after giving a chance of personal hearing, thereafter to personal approval.
I'm closing it. Hearing concluded, judgment is out. Parties may file their note of submissions and memo of citations, if any, within a week. Not necessary, but I'm just giving 1 week.
Item number 20,
The last occasion, the counter was filed by the state council, but they have not solved any copy.
Hmm?
Copy ଦେଇନାହାନ୍ତି ମଝିରେ ମାଗିଥିଲେ ବି ଦିନ ଯାଏ ମାଗିଥିଲା।
ସାରଙ୍କ ତରଫରୁ ତ ସାର୍ ଭୁଲ ହୁଏନି।
Other also
Person
have
copy
bring to reply affidavit. This there is mismatch in the documents and the information affidavit. I want to file a detailed reply affidavit by Tuesday. I have already received the instruction.
As requested by land council for the petitioner, is this matter next week on 13th September.
ସାର୍ କୋଉ କାଉଣ୍ଟର ପାଇଁ କାହାର କାଉଣ୍ଟର ପାଇଁ ନାହିଁ?
Last occasion, counter the file.
Sure.
ADM.
item 21,
20th.
It will come on 13th.
এটা ଟିକେ ଦେଖି ଦିଅନ୍ତୁ କୋଉଟା କଣ?
After lunch. All right. Pass over.
item 22,
ହଁ, ପଠେଇଦିଅନ୍ତୁ।
I'm for the petition. In this petition, was passed by the state administrative tribunal in an education appeal is under challenge.
Education tribunal.
Yeah.
FAO doesn't like.
No, it have not like appeal, it have done that.
Order which,
The order of appeal under section 10A, read petition is maintained.
this is against termination.
Yes, ma'am. Yes, ma'am.
You are, both of you are ready?
Yes, ma'am.
Huh?
Tribunal. He was working as lecturer in political science at Bharati Bihar Mahavidyalaya, Haripur, District Jajpur. He was appointed in the year 1982. In the year 1990, February, the governing body appointed one retired OES officer as the principal in charge of the college. Immediately after taking over charge, and prior to that, the petitioner not come to the college and not cooperate with anybody, take away all the documents regarding certificates, office files.
Who? Who did not?
Party number 3.
Opposite party number 3.
The GB resolution books, etc., etc. In spite of repeated requests made by the then principal, he didn't return the same. Therefore, there was a FIR, there was information to the police, sub-collector, all the government officials, and inventory was made. In the meantime, he managed to get an order of approval in his favor. When the money was not released and no step was taken for release of the amount, he filed a writ petition with this honorable court. That is the OJC number 2930 of 1990. That file has been called for.
Yeah.
The order. Pursuant to that order of the honorable court, there was an inquiry conducted by the director of higher education. The principal submitted all the documents. The opposite party number 3 was also entered appearance in the inquiry. It was found that during the period from 85 to 88, the petitioner was prosecuting her LLB, his LLB study at MS Law College, Kotak, as a full-time student. And it was further also came to conclusion that the governing body has, prior to that inquiry, since he was under unauthorized absence from the duties, the governing body initiated action against him and terminated his service on 24/1991. That is reflected under Annex 5. And this thing also reflected in the inquiry under Annex 3. In the inquiry report, it has been stated that the governing body was within its right terminated the temporary arrangement and appointments of Bhodanath Mishra, retired OS officer, as principal. And in that inquiry report, there was a finding pending verification record in the matter. CSC Board could not be, that is at page 19. CSC Board should not be considered for receipt of any granting aid or approval of appointment if the same has already been sent it should be forthwith be withheld and approval withdrawn. This order was never challenged by the opposite party number 3 in court of law. In the appeal, the very stand taken by the appellant is that though he was continuously going to the college, but he was not allowed to sign in the attendance register. He denied about initiation of any proceeding against him. But surprisingly, after thorough stripping of the college records, we in the counter affidavit, we stated that the proceeding was initiated against him. He was so cause, but he denied all the thing in the appeal memorandum of appeal, so also in the counter affidavit filed in Hon'Ble. But in fact, last occasion I have filed an additional affidavit. In that additional affidavit, I have enclosed documents. The annexure 14 is, since he was not attending college.
So that's all right, but you have to come to the order of the tribunal, which is impugned here.
Yes, just I am giving the fact, just 2 to 3 documents, so then I will go there. Miller, since he was in honor 3 absent, when the annual examination of the +2 students came, he was not allowed to give, to perform invigilation work. That is in my additional affidavit, I have enclosed the document. Under annexure 15, so annexure 14. And on annexure 15, the proceeding, this is very much vital. The proceeding was initiated against the petition opposite party number 3. That is annexure 15, page 6 of the additional affidavit. Here, on 30th/7/1990, show cause notice was issued to the opposite party number 3, stating as per GB resolution number 1, GB number 1, because the GB original resolution number was taken by him. That was not the college. That's a new resolution was opened, and by the resolution number 27/7/90, I am instructed to ask you show cause why your service in this college as a lecturer in political will not be terminated on account of following charges: absence without leave or any information whatsoever for more than 6 months, not handing over charges, misbehaving any physical assault on a lecturer. If you fail to give satisfactory reply within 15 days, your service will be deemed to have been terminated. In reply to this letter of show cause notice, the opposite party number 3 also submitted a show cause. That is annexure 16, page 7. Thereafter, I had a letter dated 10/5/1991. The governing body sought for permission of the director to terminate him from the service. But prior to that, on the next day, on 11/5/1991, the governing body terminated the services of the opposite party number 3. Though there is no valid proof of service of this letter is not available in the college office, but the issuance of show cause notice and the reply of the petitioner presumes that he might be received the order of termination, but he has not challenged this set. Now coming to this is the fact. Rightly or wrongly, the service of petitioner was terminated on 10/5/1991. This fact was intimated to the Director of Higher Education so many occasions, and under annexing what I was first pointing out, though he has very knowledge about the inquiry report, but he has also not challenged the inquiry report. Now the order of the judgment of the State and Education Tribunal, annexure 12, page 41. In that letter, the college has entered his appearance and also filed counter with the detailed documents. The order of termination was never challenged before the tribunal. The letter under annexure 11, page 38.
This letter was issued by virtue in 19 under Annexure 3. The director denied for release of the grant index. He has not challenged the inquiry report. Thereafter, he filed another writ petition in this honorable court. That is OJC number 7201/1994. In that case, but in this case, he has subject everything, even the order previous inquiry report, and simply said, then though my appointment has been approved, but salary not released. And in that case, the governing body was also not a party. There was a direction to the college to submit bill and the director to take action. In that juncture, the college authority has filed a miscase, that is IM miscase number 557 of 2008, indicating all these things and the termination of the petitioner, etc. Then there was a direction from this honorable court that the order is quoted. That is indicating aforesaid petitioner also filed miscase seeking modification, clarification of order dated 2008, passed in was 7001, and this honorable court filed order dated 25/9/2008 clarified that if in fact petitioner service were terminated, the said fact shall be informed to the director of higher education so as to enable him to take decision in accordance with the law. Immediately after, in portions of this decision, the director has also conducted an inquiry and passed order, that is page 38, annexure 11. Here, I'm reading the paragraph 3 of the order. 3 of the letter.
I've got it.
In this letter, kindly, it has been indicated that
he is not in service.
Hello?
That he is not in service since January 1990.
And the appellant has treated this letter as order of termination and filed the appeal.
Yes.
But the order of termination which was issued to him during the year 90, that was not under challenge. The London Tribunal treated this letter as order of termination and passed the order with the direction, passed the order with the direction for reinstatement with back wages.
You see, he has proceeded, as I find, on the premise that no prior approval of the director was obtained.
Accorded.
So you have to only show that much. How that order is wrong? He has quoted the relevant provision, the rules rather, Rule 22, and says that prior approval has to be obtained. You have shown me a document whereby the governing body, having decided to terminate the services of the petition opposite party number 3, writes to the director. This is under, this is at the letter dated 10/5/1991.
91.
This is for your kind knowledge to approve the termination order at the earliest.
But no approval order.
Sola setik to. How kon hoga? How kon hoga? What is the tribunal has considered it, referred to the relevant rule, that is Rule 22, which requires you, the management, to obtain prior approval. Prior approval has not been obtained. So how is the order wrong then?
What the appeal was barred by limitation. The letter issued by the director of higher education, indicating there in that your service is no more since 90. That is not, that should not be treated as order of.
Even assuming that it will not be a termination order, this court can enlarge the scope and enter into the controversy to find out, yes, what was the termination letter? You say it is 10/5/91. Even then, even if we enlarge the scope of the writ application to include that letter, even that is also without approval.
One thing is that he was throughout since 1990 till his age of superannuation.
Those facts cannot be gone into in this writ application.
She was unauthorized leave.
Maybe.
Unauthorized.
Doesn't matter. You could have proceeded in accordance with law against him. You could have thrown him out of employment after conducting a
Decision of the Honorable Supreme Court. the dismissal from service, petition is a defect found in inquiry proceedings. Order setting aside dismissal, directing reinstatement not proper. Direction ought to be given that inquiry proceedings shall continue from stage where it is stood before alleged vulnerability surfaced.
Yeah, that is true. That is true. That I will take that. I will take that. Don't worry. The thing is, now, for whatever reason, you had initiated some inquiry against him, and you wanted the governing body wanted him to be removed from service. Then it could have done that by obtaining prior approval of the director. And you yourself are now producing a document saying that you have applied to the director, requested the director to give you approval. Now there is no approval. So whatever your action, it all gets vitiated by non-obtaining of approval of the director. That is what the tribunal has said.
In that decision, that means the stage where from the position the wrong was done, the de novo proceeding,
No, that will still be open to you. You can still proceed against him. Nobody is stopping you to proceed against him.
in this decision.
But that cannot be considered in a writ application. In a certiorari jurisdiction, how can this court go into all these aspects? Say somewhere say Madhusudan Law College Padutule as a regular student, so he could not have performed his duties as a lecturer, full-time lecturer here. All these things, these are all factual aspects. You could have.
What about here, if that is out from the fact, but fact remains, he was unauthorized absent from the
True.
1990 and proceeding was initiated.
Yes.
So the stage from which the wrong was committed, liberty may be given to us to proceed for a de novo inquiry.
So not liberty, it will be open to you. You can proceed always again in accordance with law.
That, but I went to another decision. So far as back wages is concerned. In the decision of this honorable court in single bench decision, relying on so many decisions of the honorable Appellate Court, the honorable judge held conviction on charge of moral turpitude, acquittal from charges, reinstatement made without back wages on principle of no work, no pay, action challenge, no specific statement supported with document that petitioner was not guilty employed during the intervening period. No reason to interfere with part of the order dated 9/10/2019 by which claim of the petitioner for back wages has been denied based on principle of no work, no pay. Here, in this case, the honorable judge stated that there was no plea taken by the petitioner there that he was not
Gainfully employed.
So since here the clear cut thing, he was because of honest absence from duty, the proceeding was initiated against him.
That can be considered.
And he was not.
That can be considered.
Not avoid anything.
No, yes, Mr. Sharma, that part can be considered by this court.
Not employed anywhere. So he is not entitled to the back wages.
Because you see, in all cases, no work, no pay can be applied. And the general principle is no work, no pay. But in all cases, it cannot be applied. So here in this case, if you can satisfy the court that he had not performed any work, then it can be considered.
The initiation of proceeding that proves that the proceeding was initiated for unauthorized absence.
Yes. Yes, what is your reply?
Yes, my lord. In this case, I am averring for the opinion number 3. My lord, this case is not maintainable because the limitation is 60 days. They have not filed any limitation petition, number 1. Number 2,
60 days for writ application.
Yes, my lord. My lord, can we come to the section 24C?
Hold on. FAO
No, if any person agreed by this order, he preferred an appeal for anything. Time limit is 60 days. Well, look, I see.
After enactment of 24B, this
yes.
That is for GI.
But this is an order under section 10A.
10A, my lord.
10A, there is no appeal.
No,
no appeal. Writ application lies.
Writ application, I have no objection. Limitation is concerned.
Who limitation? Limitation for what?
You have to give.
No limitation from
Putting a question to myself.
limitation in respect of the writ application is concerned.
my lord.
There is no statutory limitation. You can raise the plea of delay and latches.
Yes, my lord.
You can, that argument is always open to you. When was the order passed?
My lord, the order was passed on
Impugned order. 30/11/2011 ना कितने?
30/3/2011
हाँ, writ application क्यों फाइल लगी?
22/6
तो कौन असुविधा कहाँ है? Delay of latches कौन है? तो statutory limitation नहीं.
ଆଜ୍ଞା।
आप कौन खुद?
My lord, what has happened? My lord is saying that the petitioner service was terminated in the year way back in the year 1990.
91.
91. My lord, kindly see, he has filed a counter affidavit file. Additional affidavit, page 17. They have taken a approval on 10/5/1991. When the termination order was passed, next day, 11/5/1991. That approval is not taken into the prior approval is not taken by the director.
Argue on the question of back wages. That point is taken.
Yes, madam. My lord, I have no legacy. I had gone to the college each and every day. The governing body and as well as the principal did not allow to put my signature in the attendance register. When I have filed a writ application, I was a approved employee, my lord. My post was approved. When I am not getting my salary, I filed a writ application before this Hon'Ble High Court. This Hon'Ble High Court disposed of this matter with a direction to the director to release his salary. Well, kindly come to my counter. Page 18.
Annexer. Annexer.
Annexer D/3.
Yes.
Running page 17. Come to the page 18, my lord. This Hon'Ble Court disposed of this matter. Kindly come to the para 3.
Yes.
Considering all these facts, this court disposed of this writ application directing the principal of the college to submit the arrear bills of the petitioner within a period of 6 weeks from the today before the director of higher education Odisha Bhubaneswar, opposite party number 2. After receipt of these bills, opposite party number 2 shall scrutinize the same in accordance with the law, and he is satisfied that the office order number such and such dated 23/1991 has not been varied or modified in the meanwhile, and the petitioner is entitled to the arrear amount claimed by any part of thereof. He shall pass necessary order for disbursement of the same as expediently as possible. After disposal of this writ application, may I come to the annexure E/3, page 20. The principal of that college sent the pay bills to the director. May I kindly come to the E/3.
E/3 is something else. This is an information sought for.
Yes, my lord. So, under the RTA Act, my lord. They have taken a stand, my post was terminated. After 2008, the principal sent the pay bills to the director. How my termination order was passed by my learned friend saying that his service was terminated. When my service was terminated, they have never communicated to me. They have not disclosed anything. My lord, then my lord, after disposal of this writ application, my learned friend filed a miscase without giving an opportunity. This court was modified to send back to the director to inquire this matter. My lord, come to the page 43, annexure F/3. My lord, come to the page 44.
So this stance which you took to took it, carried it to the education tribunal. This order.
Yes, my lord. After they have disclosed, my service was terminated way back in the year nineteen
How
ninety.
does this prove that you have been, you are in continuous employment? You have been terminated. Yes, according to the tribunal, wrongly, because no approval of the director was obtained.
नहीं आगे move पाएगी गली tribunal को. After the disposal of the director order, when they have disposed, my service was terminated in the year 1991.
No, he says Sri Bora is not in service and has not performed duty since January 1990.
Well, kindly come to the page 44.
No, 44 the board.
Para 6 ticket देखो. That the services of the petitioner Sri Sashikanta Mishra has been terminated. As reported by the principal and another substitute, namely Sri Girish Shankar Mahanti, has been appointed against the first post of previously held by the petitioner. That after verifying the records and a report of the principal, it is found that the petitioner Sri Bora is not in the payroll of the college and it is absent from the duty January 90 till date. They have taken a step 90. I am not working in that college. Under annexure E/3, I have obtained the RTA information. They have sent a pay bill in the year 2008. Number one. After the termination, I prepared an appeal before this state education tribunal under section 10. The learning tribunal disposed of this appeal with a direction to reinstate me and give me all the benefits. My lord, another thing is concerned, my lord. My lord is saying that I was a student of the law college. My lord, kindly see annexure H/3, page 49.
Yes.
Last paragraph. That the GP, governing body, permitted Sri Sashikanta Mishra to study law in a period of 3 years from 1985 to 1988 without interfering of the college by mutual and adjustment of class at MS Law College, Kotak. Bharati Bihar, Narayan College, Haripur. The governing body passed a resolution. They have given a permission to me to go to the admission, and 3 years you have study. They have taken a stand. He has gone to the MS Law College in a regular student. He has not taken any permission. This is the letter, my lord. Annexure H/3. Last thing, my lord. They have terminated my service. When the governing body was approved, the outgoing member filed a writ application before this honorable court under annexure J/3. That was stayed. This approval order was stayed. By this honorable court. My lord, on 29/10/90, page 53, my lord.
Yes.
There shall be interim stay of operation under annexure 6, approval of the governing body. Once the governing body approval was stayed, how they have terminated my service? He is not a competent authority. That approval order was stayed by this honorable court. Then they have disclosed in the year 2008 when I have filed an appeal before this director. That time they have disclosed my service was terminated. It is the factual aspect, my lord. The law is concerned, my lord.
We'll continue next week. This matter next week. Pattern দরকার নেই, send it.
Okay. Item 23.
Dated 16/8/2024, my lord has directed to state government to take instruction whether the certificate.
Sida on the basis of request of this also then
There has been
This court would like to peruse the letter dated 3/2/2010 of the Tahsildar Nimapada, basing on which the sub collector had held that it's not a genuine certificate. Yes.
Asking out from Lordship, I call it on 17th or.
The state is not complying with any order. Kabu thire aaya apun time no chhu.
In many cases, I am troubling your Lordship because of.
Why many? All right. As requested by the State Council, let this matter on 20th September. The previous order be complied with positively. When adverse order pass over, tapra comply hobo.
Sir,
You saw what happened to that
director.
no, not that director. That file. How it was traced out. When the chief secretary was directed to inquire, the file was immediately.
Director has.
The मूल से चापी के रखी थे जब चीफ सेक्रेटरी जाए कथा कला बाहर कले
ଚାପିକି ରଖି ନଥାଇ ପାରନ୍ତି।
ମୁଁ ଜାଣିଛି ମତେ ଆଉ ବୁଝେଇଲା ହବ
Not orderly, having not kept the files in orderly manner.
ଗୋଟେ deliberate chaos ବୋଲି ଗୋଟେ concept ଅଛି ଜାଣିଛନ୍ତି creating a deliberate chaos ତ ସତଟା ବାହାରିବନି
There is no seeming reason here in the instant case, in that case.
anyway obtain that order please yes item 24 24 to 24 yes
When the petitioner is working as a Hindi teacher, part-time Hindi teacher.
state is the opposite party
Yes, sir.
why the selection list under annexure 5 shall not be quashed and the petitioner shall not be engaged as part-time Hindi teacher of KGBV Haldi.
Counter has been filed in the case.
Hey, where is the counter? It is not on record.
Copy has not been given also.
It's not counter filing. It has been filed long since 2012.
बंद करो. The court record does not have your counter.
Filed.
File is
ଆମର ଲେଖା ହେଇଛି 17/7/2012 କାଉଣ୍ଟର ଫାଇଲ ହେଇଛି ବୋଲି ତାଙ୍କୁ କିନ୍ତୁ କପି ସର୍ଭେ ନି ବୋଲି ଆମ ପାଖରେ ଏକ୍ସଟ୍ରା କପି
Copy not served.
ଆମ ପାଖରେ ବି ଆମକୁ ବି ସର୍ଭ କରିନାହାନ୍ତି ମେନ୍ ଲୋକଙ୍କୁ ସର୍ଭ କରିନାହାନ୍ତି ଆମେ କରିବୁ କଣ ଆଜ୍ଞା ଦିଅନ୍ତୁ କାଉଣ୍ଟର ଫାଇଲ କରନ୍ତୁ then state council should I say that you are filing counter in the court
yes
then copy of the counter
ଆପଣଙ୍କର
no it is not there it is not there ଅଛି ଦେଖ physical copy ରେ ବି ନାହିଁ
ତାହେଲେ affidavit କପି ଟା ଅଲରେଡି ଫାଇଲ ହେଇଛି
କୋର୍ଟ କପି ଟା ଆମ ପାଖରେ ଥିଲେ ତ ଏଇଠି ଦେଇଥାନ୍ତେ।
ସେତେବେଳେ ତ ଇ ଫାଇଲିଂ ଫାଇଲ
e file ତ ନଥିଲା ନା ସେ ସିଧା hard filing ହେଇଥିବ hard filing is not there in the you file another copy end of the matter
with supporting with an affidavit ମାନେ
ଆଉ further କାଇଁ already if it has been shown affidavit ହେଇକି file ହେଇଥିବ ନା
ଯେ ଆମ ପାଖରେ ଜେରକ୍ସ ଟା ମାନେ affidavit କପି ଟା ନାହିଁ ବର୍ତ୍ତମାନ ଯୋଉ ପାଖରେ ଆମ ପାଖରେ କପି ଅଛି
state council submits that the that counter was apparently filed on 17/7/2012 but the same is not on record let fresh counter be filed after serving copy on the other side. List this matter on 27th September.
Item 25.
In respect of appointment of the Anganwadi worker, my lord. I am filing the agenda today. The agenda doesn't contain any additional facts, my lord, only submission of copies. My genuineness, that is only there. They say that I do not belong to the village.
Land counsel for the petitioner files copy of the rejoinder after serving copy on the state. The same be kept on record. Yes.
Their main contention is that I do not belong to the village Gindlamal. But I have given all the documents, my lord, wherein I have stated that I belong to the village.
So what was the residential certificate?
Residential certificate is annexure 3, my lord.
So these things cannot be taken note of, Mr. Purohit. These things cannot be taken note of by the court. What does your residential certificate say?
My residential certificate says that I belong to Gindlamal. I have submitted the residential certificate, which is annexure 3 years, my lord.
Which suppose these documents are in,
Two,
no, these documents are in support of the residential certificate.
my lord.
And then now document kon hobo? Jodi residential certificate achi, that has been considered.
Residential certificate could samana doubt kole boli. The CDPO called for the report from the Tahsildar regarding the validity of the residential certificate. Tahsildar has submitted the report again by annex of 4, my lord, that this is the true residential certificate. That I belong to village Gindlamal. Thereafter,
I
they
will
have
to notice that
submitted
Srimati Sanjita Khura has submitted resident certificate of residence that she is permanent resident of village Gindimal,
Gindlamal.
Ginlamal.
My lord,
The villagers of Ginlamal have alleged that she is a resident of village Mundo Mahal. As desired by the selection committee, you are requested to inquire the matter. Tapre, what is the report?
the report they have given the report by annex of A by 3. That is a
No, survey list nahi. What is
Survey
the
list.
what is the reply to this request of the CDPO? What is the
they are annex of 4, my lord.
once a certificate has been issued under the miscellaneous certificate rules,
My lord,
so that stays
my lord.
unless it is modified or withdrawn, cancelled, whatever.
My lord, the CDPO asked for verification of the certificate by annex of 3, my lord, annex of 4.
Annexure 4, he asked, what was the reply?
My
By the
reply
Tahsildar.
is annex of the next page, annex of page 14, my lord.
Page 14.
With reference to the letter on the subject cited above, I am to say that residence certificate in favor of Srimati Simarani Suna, daughter of Chaitan Suna, has been issued by Miss Case certain number so and so, and residence certificate in favor of Srimati Sanjita Khura, the petitioner, has been issued by Miss Case number 4674 of 2012, Gindla Mall.
So next line data padhantu, very important.
In this connection, enquiry was made finally came to the connection that above two residential certificates were issued as genuine and may be treated as valid.
So this seals the fate.
My lord.
What more? Mr. Das?
Sir,
If
authority,
the authority concerned, the Tahsildar himself,
competent authority.
yes, he says that the resident certificate is genuine. How further survey report kono dekhibo, Aadhaar card kono dekhibo? Unless it is cancelled. Unless it is said that it has been fraudulently obtained, then he has to file an appeal. Review is there?
Yes.
So that is the point. What is your counter? You have given some survey list and all that.
My lord, survey list is preparing.
How do these documents override the residence certificate? Otherwise, because that has been issued under a statutory provision, it's a
Yes.
rule.
Miscellaneous
Yes.
certificate rule.
How can these documents prepared by the local Anganwadi workers and health workers and all, survey register and all that, how can they override the residence certificate? If there is any bona fide objection that she is not actually a resident, but he has managed to obtain a residence certificate, then there should be a challenge to the residence certificate before the appropriate forum. That is probably the sub-collector, I think.
Yes.
It can be challenged before the sub-collector in an appeal. And all came to. Where is the order, impute order?
Or is it annex of 5, my lord?
Annexure 5. ଏତ ଦ୍ୱାରା ଗିନ୍ଦିଲା ମାଲ
ଗ୍ରାମ ସର୍ବସାଧାରଣଙ୍କର ଅବଗତି ନିମନ୍ତେ ଜଣାଇ ଦିଆଯାଉଛି ଯେ ନୋଟିସ ନମ୍ବର 587 ଡେଟେଡ 19/11/2012 ଏ ଗିନ୍ଦିଲାମାଲ ଅତିରିକ୍ତ ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ରର କର୍ମୀ ଚୟନ ପାଇଁ ଆବେଦନ ପତ୍ର ଆହ୍ୱାନ କରାଯାଇଥିଲା, କିନ୍ତୁ ଅନିବାର୍ଯ୍ୟ କାରଣବଶତଃ ଉକ୍ତ କେନ୍ଦ୍ରର କର୍ମୀ ଚୟନ କରାଯାଇ ପାରିବ ନାହିଁ ଓ ଉକ୍ତ ବିଜ୍ଞାପନକୁ ବାତିଲ କରାଗଲା।
So how does this affect you?
Notification was withdrawn.
Notification was withdrawn.
Without citing any reason.
Yeah, they have whatever appeared to them, they have.
No, they have not said anything.
Anivarya.
Anivarya karana.
They have said in the council.
In one of my judgments I have held, you cannot cancel it by saying arbitrary action. You can cancel it.
Specify the reason.
You have to specify এই কারণ পাই আমি cancel করব. That is the constitution bench decision of Sankarsana Das. Where it has been held that merely because of your inclusion in the select list, inclusion of your name in the select list does not give you a vested right. That is true. It is also true that the state can also, the employer can always withdraw it, cancel it, but citing appropriate reasons. Arbitrary action, this becomes an arbitrary action.
For a matter of 2013.
ये सार तो दबाओ रखिए कि सार दबाओ ये थाओ आरो वीक थाओ जजमेंट अछि मोर जजमेंट सर
ନୂଆ ତ ଦେଇପାରିବେନି ସେଥିରେ ଆଜ୍ଞା।
कोन आउ देबे कोन
ନୂଆ ଆଉ କିଛି ଦେବାର ନାହିଁ ତେଣୁ।
किछु न जा तो अछि मु I will not even look into this. I think the points are crystallized now. Anything else?
No.
Keep it on record. Are we going to शुक्रवार?
Will it again be listed or the?
No, it will be listed. Otherwise, the burden will be on me. Motivation. Burden part list this matter on 13th September. I could have completed it, Mr. Purohit, but judgments are there, so.
Item number 26.
Yes.
Yes, madam. The petitioner was appointed as ASA of Bornapat Gram Panchayat under Jagrai Gram Panchayat under the medical officer CSC Kumna in the year 2006. She continued up to 2016. In 2016, there is a group class between two sections of group which leads to death of a person. Lordship, annexed to page 14.
How?
Next.
All matters, all the matters of who? 32. Will be taken up with the next week, madam.
Right, now 41. That means second appeal. Next week. Not today.
ERPC would have, yeah. ERPC would have.
Words. Yeah, this is not the other bail matters and all. If anybody is interested for second appeal, which I don't think in the gloomy weather anybody will be.
Right.
No, the problem is, once I complete it, the meter starts running. I have to deliver the judgment. So that is why I am staggering it.
Lordship, the interim orders in the
Burden on the other,
Sir?
burden on the other side increases.
Naturally. That is why the other matter I had completed it. And even Mr. Sharma's the other matter which was arguing, I had completed it. Nothing, I made up my mind. But to dictate the judgment will be again, it will take some time. So.
Sir, how did the passport?
Passport रखितो.
Passport ଦେବେ ନା
No, sir, ଆପଣଙ୍କର କଣ time ଲାଗିବ ବହୁତ ସମୟ?
ନାଇଁ ମୋର ସାର୍ ଗୋଟେ ଦିଟା ଅଛି ମତେ 10 ମିନିଟ୍ ଅଧିକା ଲାଗିନଥାନ୍ତା ମୋ ପାସପୋର୍ଟ ହେଇଯାଇଛି।
ସେ 2009 ମସିହା matter ତେଣୁ
ନାଇଁ ସାର୍ ମତେ 2 ମିନିଟ୍ ମତେ 10 ମିନିଟ୍ ଦଉନାହାନ୍ତି ମୁଁ ସାରିଦେବି ସାଙ୍ଗେ
କେତେବେଳେ?
ଏଇ ସାଙ୍ଗେ ସାଙ୍ଗେ।
Dismiss 44.
Item 34.
Next week. None appears next week.
Item 35.
Liquidated already filed. Already filed.
Requisites was directed to be issued in November 2017. When did you file?
Today.
Today?
Yes.
No.
In course of the day.
No.
I can say.
ହବନି 2017 ଆଜ୍ଞା pending ରଖିଛନ୍ତି and there is a stay of the lower court proceeding. No. Dismissed for non-filing of requisites, which was directed to be filed way back on 14/11/2017. Yes.
Item 37.
36 37. None appears next week.
Item 38.
And 38 I am for the opposite party husband.
Who's for the petitioner? One.
The opposite party has filed a mad case before the civil judge senior division Kamakyanagari. And now the present petitioner is residing at Talche with his paternal house father. So the distance is around 48 kilometers and he wants to, as she has no income and she is depending upon her father, she wants to transfer that case to Talche. And in Talche, another proceeding, maintenance.
Any chance of settlement?
No, Your
There
Honor.
is no chance.
No.
Yes, what is your?
Lordship, there is another case, criminal case is also pending in the additional district sessions judge before the district sessions judge, Kamakhanagar. And
You want it to be transferred from Kamakhanagar to Talche?
Talche.
Yes.
And another case is also pending before the same court where the MAT case is filed. That is a petition under section 24 of Hindu Marriage Act for interim maintenance. And all the dates has been fixed to 1st of October 2024.
In the meantime, he has already got married to another lady.
That I have no instruction on that. But the 3 cases are pending in the court at Kamakhanagar. Here.
If 3 cases are pending at Kamakhanagar, then and you have not sought for transfer of those 3 cases. This one case, why will it be transferred?
I don't. So the case which my grandson is saying that 24 for
Maintenance.
maintenance for
No.
125 and file.
How many cases are pending? You file a chart. Both parties. Huh?
Yes.
Both parties are requested to file to submit lists of cases pending between list of cases pending between cases involving each other.
May I submit my
Said to be pending before different courts. This is matter next week.
May I submit my the case list of cases I have?
Let him check. Let him check. Interim order to continue.
Lordship, there is no IA for interim order.
Lordship, interim order.
No. There is no IA for interim order. I have checked. There is no prayer for interim order.
I'll have a glance to order dated 19/1/2022.
Correct.
On that.
This court has already granted stay.
Lordship, that order was passed only for the subsequent further orders.
Yes.
Thereafter, no IA has been filed for extension of that.
Not necessary. Not necessary. The High Court has inherent power to stay any proceeding.
But
Are you aware of it?
Yes.
Don't raise these technical problems, please. If you have anything on substance, say. When we are hearing this matter, the proceeding before the court below will it's appropriate that it should be stayed. Interim order interim order dated 19/1/2024 shall continue till the next date.
39.
May I please? In this case, I am for the petitioner, wife mine. I pray for transfer of petition 13(1) year of Hindu Marriage Act from Judge Family Court of Raulkela to Judge Family Court Kendrapara, which is the more than 300 kilometer mile. Present petitioner is unable to attend this court, my lord. Since the 125 proceeding is pending before the Judge Family Court Kendrapara.
There is another transfer application.
Which is the disposal of, which is filed by the husband, which is the disposal and dismissal.
I mean, pardon, my lords, I'm appearing for the opposite party husband in this case, my lords. My lords will file a counter to the petition, my lords.
No, before that, is there any chance of settlement?
It's very bleak, but I'll seek instructions in that regard.
Yes, what do you say?
Hello?
Is there any chance of settlement?
No interim order.
Is there any chance of settlement?
No, there is no.
No chance. How do you know?
The internally and deliberately, the present petition or husband.
All matrimonial cases are like that. Some clash of ego, emotions. So, yes, what do you want? What do you say?
My lords, I'll file a counter. I pray the matter may be taken up sub under there. Within the meanwhile, I'll seek instructions with regard to reconciliation as well as file a counter to this.
All right, all right.
Let the matter before the conciliation shall.
No, let it come. Let her take instructions. Let this matter on 20th September to enable learned counsel for the opposite party to take instructions from her client as to if there is any possibility of amicable resolution of the dispute between the parties. All right. And counter, if you want, you can file. You don't need an order from the court.
Item 40.
Actually, Lordship, item number 36 में permitted to withdraw, Your Lordship.
Item 36. Withdraw the each. Item 40. Yes. AD not back from OP. Postal tracking report देखिए कौन है जी? Let it come next week along with the up-to-date postal tracking report. Say out for delivery each in an item delivered. Yes. Postal tracking report shows that notice on the opposite party has been served. There is, however, no appearance. But a service tech page on A cartridge.
Next week.
Okay, time daba.
Again.
Let's this matter on 20th September to enable the opposite party to appear. Yeah.
Item 41.
Is there any interim order?
No.
Yes. Item 41.
May please.
Husband application में उस पे मार दूँ.
Husband application तो हवा कथन में किंतु ही गला.
नहीं ହେଇଗଲା ଯେ divorce case file करते से wife जिन से appear करते. ठीक है हम देखिए भी और lordship was pleased to issue.
ये नहीं भूल रही है तो.
ना देखिए कि तो भूल गई.
सब कौन देखा जाऊँ? सब कौन देखा जाऊँ? Yes.
No, I has been filed to include the respondent number 2.
For amendment.
Consolidated cost also filed.
Amendment of what?
Annexure 1, Annexure 1 page 8 minor ambulance. That Padma Digal was added as respondent.
You want to include him as a party?
Yes.
All right. Application for amendment is allowed.
Consolidated cost also.
Not party.
Is allowed. फिर आइए 278 रोज है ना?
Copy টা সব করি।
এইখানে দিয়ে দিন তো।
नहीं आइए रे कॉपी टा मिलची और मिलट कॉस्ट एट कंसोलिडेटेड कॉस्ट एट
The respondent number 2, Padmacharana Digal, in the court below, be implemented as opposite party number is implemented as opposite party number 2 in the present case. Consolidated cost title has been filed in the court. Copy thereof has been served on the other side. Yes, what is this matter?
Wife's application seeking transfer from Kotak to Fulwani.
Kotak to Fulwani. Settlement?
Lord, Judge, High Court Mediation Center have no objection because this is a very special case.
Mediation, but in fact, her father has been died. Old mother, which she is staying with her old mother. Let they provide the.
Milord, this is a very
expenses for
special
traveling
case.
so that-
Kindly have a glance to my case is that the notice is served upon the petitioner at Bhubaneswar where she is residing with this paramour, opposite party number 2. Now, when it is prima facie proved that the petitioner is residing at Bhubaneswar with the paramour and her mother is giving repeated threats to me if I go to the
settlement,
she will file a SCST. I am belongs to general case, the law of marriage. Her entire family is threatening me. If I reach there, they will file several cases, particularly SCST, PA. This is my in my averment also, my lord. If I go, I will be highly prejudiced and there is a utter threat to my life.
No, that is a different matter. I'm just asking for mediation. What will come out of it?
Mediation,
Accepting.
that may be this way or that way, that may happen, my lord. Either they will reunion, but in the present circumstances, where this Padma legal is also having, is a person with the criminal.
We have not issued notice to that opposite
No,
party number.
notice kindly be issued to that.
So let us issue notice.
My lord.
Here, my lord, we have no claims.
How can they say? Because it means there is a collusion between the OP number 2 and.
No, it is at his risk. It is, if he wants to dispense notice, it will be at his risk.
Because I am seeking transfer
As
because.
submitted by learned counsel for the petitioner, notice on opposite party number 2 is dispensed with for the time being at his risk. At the risk of the petitioner. Hello?
ଯଦି କାଉନସିଲିଂ ଯିବ ମିଲଟ ଗୋଟେ ହେଇପାରେ either the reunion ର ବର୍ତ୍ତମାନ ଯେହେତୁ adultery is involved there may not be a reunion, maybe the other part may be possible, that can be done, but sending
Negative
me to
settlement.
such a distance where it is in my pleading that they are threatening me to put me in SC/ST.
That's all right. This is what happened. So this can be, if you agree, Mr. Dwivedi.
No chance of my lord. Since he is making allegation of adultery in the petition, no chance of.
I am praying for both in both way, my lord.
Chhad dein. We'll take it up on some other day. Raise this matter on 27th September. Interim order to continue.
Deep lovely.
42.
The requisites file be accepted and notice be issued as directed by fixing a short returnable date. List this matter on October. Huh? Shooty par 25th October.
Item 43.
Pray for next week.
Next week as well.
Item 44.
The opposite party approach.
There's nobody for the petitioner. Next week. None appears for the petitioner next week.
Item 45.
I'm for the opposite party. For the opposite party.
None appears for the petitioner next week.
Item 46.
None appears next week.
Item 47.
Same order. Requisites file be accepted and notice be issued as directed, fixing a short returnable date. List this matter on 25th October. Interim order to continue.
Item 48.
Only intention to file this application, my lord, that there will be conciliation at High Court.
Mediation center.
Again.
No matter that they have already, she is already gone to the Mahila Commission and that is failure. And the only this they have not taken any grounds, matters. The only ground is that they will not get justice from the family court Bhubaneswar, so they want page 6 para 14 matters. That is the only ground.
Conciliation again, 8 ବର୍ଷର ବାହାଘର. Wife ଆଜ୍ଞା ଚାହୁଁଛି ସେଇଥିପାଇଁ ଆଜ୍ଞା ମୁଁ ଫାଇଲ କରିଛି, ନହେଲେ ମୁଁ କଟକ ଭୁବନେଶ୍ୱର କାହିଁ ଫାଇଲ କରିଥାନ୍ତି? Only for conciliation, my lord.
That is already part she filed this before the Mahila Commission.
Yeah, but why don't you agree for conciliation? Whatever has happened has happened.
I'm not no.
So whatever has happened,
Yes.
has happened.
Yes.
So why don't you agree for conciliation?
No, I'm not.
Only
I'm saying the fact.
All right. It is stated at the bar that the dispute between the parties, the nature of the dispute between the parties is such as can be settled amicably through the process of mediation. Mediation is out of this matter.
22nd November.
22nd November? If is there an interim order?
No, I don't like it.
There shall be stay of further proceedings of such and such. See, if the mediation fails,
Again.
then we'll take up the transfer application for whatever it is worth. Yes.
Item 49.
Extension of time.
First time.
No, man. That is second.
1 week time.
2 weeks. They are in court. 2 weeks.
2 weeks time is allowed. There shall be no further extension of time.
Item 50.
It is that, your lordship, modification was done once. And
Yes.
Second time, your lordship refused to consider. Because first bail petition application we had filed, there was rejected on the allegation that the other application was allowed on the ground that I am the prime accused. But the other time was demonstrating, no, the allegation is similar. But then lordship refused to consider. So there is no scope for filing again. So what I am submitting, I am withdrawing appropriate relief, whatever possible I do.
No, because I have already modified it by saying that principle of parity should be
That
extended.
the learned trial court said no. High Court did not give, why should I consider?
No, is it, have you stated so in the affidavit? On affidavit? Then I can take cognizance of that, I can pass an appropriate order. Saying that you, if the court, why will you make that allegation against that?
Maybe I had filed it, I have filed a certified copy of the order. I have,
No, that the court says that since the High Court has refused, I will not grant you bail. That,
I will check up your lordship. How asa aro sukbar asu.
no, se mane semti bhi karibata thik bhi hoboni that
Nahi,
poor officer will be in trouble. Why should we do that?
normally we don't say.
Normally, I know.
Invariably we don't
I
say.
know. It is always a mutual relationship. The judges are protected by lawyers and lawyers are protected by judges. That is how we
No,
survive.
that is not, we are not opposing each other that way. So I was demonstrating the other day that because I have filed also the charge sheet.
No, when the High Court says that you follow the principle of parity, since it is submitted that several accused persons have been released on bail, so then what business does the court below have to say that the High Court has refused bail, so I will refuse bail?
So ଏମାନେ withdraw କରି petition ଟା ନେଇ ଆସିଲେ ଯୋଉ surrender କରିଥିଲେ they withdrew the petition because court said no I am not going to consider. And I filed that certificate copy.
I can always say that you are making this submission that you apprehend that the court may not grant since this court has earlier not granted you anticipatory bail. But I will reiterate that since this is there, his apprehension appears to be unfounded.
Yes, sir.
That may help you. See, S.K. Sonangil and senior counsel appearing for the petitioner submits that the order be further modified as his client apprehends that his application for bail may be rejected by the court below, as this court was not inclined to grant anticipatory bail to him. Stop. Then State Counsel submits that the apprehension of the petitioner is not reasonable, as the court below has not passed any such order. Stop.
And your lordship's earlier observation.
This court observes that by order dated 24/1/2024, while not being inclined to grant anticipatory bail to the petitioner, this court left it open to him to surrender before the court below and to move for bail, to be considered on its own merit. Stop. Subsequently, by order dated 26/7/2024, said order was modified by adding the following. Stop. Since several co-accused persons have been released on bail,
all except me,
and this court has not specifically rejected the application of the petitioner for anticipatory bail, but granted him liberty to move for regular bail before the court below, and also to claim parity, his apprehension that he may be taken to custody on his appearance appears to be unfounded. Stop. The application for modification is therefore disposed of accordingly. That is the only thing that can be done, nothing more.
under this circumstances.
Pardon my lords, I permitted to make a mention.
Yes.
Item 45.
Yeah, go ahead.
Yes, my learned friend is there.
ଆଉ କିଛି କରିବନି ନେକ୍ସଟ ୱିକ୍ ଆଉ ଆଜି ଆଉ ମୁଡ୍ ନାହିଁ ପଶୁଆ ଯିବା ଆଜି ଆଉ ମୁଡ୍
ଖାଲି ନନା ପେସ୍ଟା କଟା ମୁଁ ଦୌଡ଼ିକି ଆସିଥିଲି।
ହଁ ନନା ପେସ୍ଟା କାଟିଦେବେ ନନା ପେସ୍ଟା କାଟିଦେବେ ଆଉ କିଛି କରିବନି ହଁ ନେକ୍ସଟ ୱିକ୍
As your lordship.
Item 51, may I lordship please?
May I what? May you what?
May I lordship?
No, you said may I may I what? କୁହନ୍ତୁ
ये APL 1189/24.
ହଁ
20 B to C.
Only prisoner's petition?
No, my lord.
How?
3 times of. That 3 times I already said I shall have 3 times.
Acha.
So noting doesn't rise.
Oh, Korea. Yes, what do you want?
My lord, 20 B to C. My lord, 250 kg.
Yes.
8/8/2023 two co-accused two accused already arrested. But one the co-accused statement I am arrested. 2/4/2024. No, 2/1/2024. I have no criminal antecedent, my lord. Only for the co-accused statement I am arrested.
Yes.
Yes, my lord. On the basis of co-accused statement, he has been arrested from 2/1/24. And there was 3 accused person, and this person managed to escape from the spot, my lord. Later on, he was arrested, my lord.
Later on?
Yes, my lord.
On the statement of...
On the statement of one Prakash Sahu and Rajesh Biswal.
The petitioner is in custody since?
Since 2/1/24.
2/1/2024. In connection with such and such case. It is alleged that that a truck carrying 250 kgs of contraband ganja was being transported when it was detained by police. Kete jana arrested spot re?
2 persons, my lord. One Prakash Sahu and Rajesh Biswal.
2 persons, namely Prakash Sahu and Rajesh
Biswal.
Rajesh Biswal were arrested at the spot. Stop. Neither the affair nor any other material available in the case diary reveals that the petitioner was present at the spot. Stop. The petitioner was subsequently taken to custody on the basis of the statement of one of the co-accused, namely
These 2 persons, my lord. Being further asked, they disclose the name and address of absconded suspected person.
One of them on the aforementioned above named co-accused persons. Stop. There is no other independent material to show his complicity in the alleged occurrence. In such view of the matter, the ratio decided in Tufan Singh versus so squarely applies to the facts of the case. As such, I am inclined to allow the prayer for bail. Let the petitioner be released, such and such. Appearance before the IAC of Kothana, Gochapada police station on every Sunday at 10 a.m. till conclusion of trial. Each day appearance before the court below without seeking representation.
Sub-item time. Sub-item, my lord, there is.
Yes, sub-item. Rajesh Biswal. You are the
Rajesh Biswal that has been disposed of before the learned court below. And I filed the surrender certificate on 4/9/2024. मैं टेक्नो पे नहीं आता
No. सरकार तो
डिपोजिशन था
नहीं डिपोजिशन कौन आपको जहाँ रिलीफ दवा था दिले ऑडिशन कीजिए कितने रिलीफ देवी
I would डेट कर
नहीं आप डेट से कौन हो आज ही सर you are filing surrender certificate. As per surrender certificate filed by the petitioner in the court below, in the court today, it appears that the petitioner
filed in the registry on 4/9
has surrendered to custody after expiry of the interim bail on 4/9/2024.
No, surrendered on 9/8/2024. I have filed the surrender certificate on
4/9/2024. The main bail application is taken up for hearing. हाँ अच्छा 1,750. The petitioner is in custody since 8/8/2023 in connection with such and such case. It is alleged that a truck carrying 250 kgs of contraband ganja was being transported when it was detained by police. Permitted to withdraw.
Item 52. May I please, Your Lordship. My lord, I have filed the IA. That case, my lord.
What?
IA, my lord, I have filed this application, my lord, because your lordship was not.
Filed in this 6766.
My lord.
676.
This is the disposal of case.
No, my lord, I have filed the fresh case, my lord.
But earlier this matter was disposed of by this honorable.
So
court.
in that disposed of case, you have filed an IA?
No, my lord,
Oh.
fresh case. Fresh case, I have filed this IA. As because, my lord, that court is not functioning. For that reason, this case is, my lord, lingering since long. For that reason, my lord, I have filed this application on the changing circumstances. Earlier, my bail application was disposed of by this honorable court on merit.
Rejected.
Yes, my lord, rejected. Not once, but thrice. Fourth time, my lord, my bail application was rejected, and your lordship was pleased to allow some period, my lord, interim bail, and then petitioners, my lord, surrender in time. And at present, he is in custody. Subsequently, my lord, I have filed this bail application on the changing circumstances. That in number one, that is the long detention, my lord. I am in custody since, my lord, that 10/4/2022. I am in custody, and in the meantime, my lord, out of that witnesses, 37 charge sheet witnesses, 38 charge sheet witnesses, 17 witnesses, they have already been examined, and 14, they have not supported the prosecution case. And my lord, other 2 to 3, they are the maternal uncle of the deceased. He has supported the case, but he has not seen or he has no direct knowledge about this occurrence's concerns. Thereafter, my lord, the court, another ground, my lord, for playing before this honorable court for consideration of my bail application, that the court is not functioning since long. For that reason, my lord, I am.
Which court? ADJ?
My lord, that pending.
ADJ Kendrapada?
Yes, my lord. For that reason, my lord, I have.
There is an application for interim bail filed by the petitioner on the ground that the presiding officer being absent, the trial has not progressed. The trial is not progressing. Out of the total witnesses, 38 charge sheet witnesses. 17 witnesses have been examined. Stop. The petitioner has been in custody for more than 2.5 years. Stop. Thus, citing the ground of delay, it is prayed that the petitioner may be released, at least on interim bail. Also, as his father is suffering from some cardiological ailment. Then State Council has opposed the prayer for interim bail on the ground that the petitioner was earlier released on interim bail. Though he fairly submits that that he had surrendered in time, yes, without misusing his liberty. Considering the submissions as above and the grounds cited in the application, I am inclined to take a lenient view. Let the petitioner be released on interim bail for a period of 2 months.
May I submit, my lord? I am appearing for the interim. In the earlier bail application, the petitioner was granted the interim bail for the period of more than 3 months. And during that period, the petitioner misused the liberty given to him, for which an FIR is registered against the petition, my lord.
Learned counsel for the informant, however, State Council however, submits that on the last occasion, that the petitioner, while on interim bail, had threatened the informant. Dilip Kumar authorized the informant. Threatened the informant, for which a case has been registered against him in Kudan Nagari PS under section 506 and 507 of IPC. Yeah. Yes. Yes. Yes.
Item 53.
My lord.
Take instruction regarding that case.
506, 507,
CV final form.
Even 323 I would have taken note of it.
Again, CV final form is a mistake of fact only.
I have no.
And this case, my lord, pending. Keep it pending.
The case, list the main case for hearing on.
After
2 months.
2nd September in November.
You know the fate of the case of ଯେତିକି relief ନେଲେ ନେଲେ
ନାଇଁ ସେଦିନ ବି ସେଇଆ ହେଇଥିଲା ମାଇ ଲର୍ଡ ମାଇ ହମ୍ବଲ ସବମିଶନ ଆଗରୁ 3 ମାସ ଥିଲା ଯଦି 3 ମାସ କରିହବ ଆଇ ୱିଲ୍ ଡୁ
ମୋର humble order ହେଲା
ମାସେ extend
ମୋର humble order ହେଲା 2 ମାସରୁ ଅଧିକା ହବ
Item 53 Miller, 72 years old man Miller, custody 21/8/2024. I filed a IA Miller because Miller running.
କଣ 21C ବ୍ରାଉନ ସୁଗର
532 ଗ୍ରାମ।
ରହିଲେଣି ଆଜ୍ଞା 3 ବର୍ଷ ପରେ 72 ବର୍ଷର ବୁଢା ଲୋକ ଆଉ out of Miller 19 witnesses, only 2 witnesses Miller examined by the trial court that has been reflected Miller annexure 3 paragraph 4. 2 ମାସ ମଧ୍ୟରେ ଯାଇଥିଲି ଠିକ ସମୟରେ ସରେଣ୍ଡର କରିଛି ଆଉ ୱାଇଫ ଇଂଲିଶ ଗ୍ରାଉଣ୍ଡ ନେଇକି ଆଉ ଗୋଟେ 2 ମାସ କହିଥିଲେ ଆଉ ଏଇଟା ଫାଇଲ
ମୁଁ କହିଥିଲି ଏ ଫେଲ କରିବୁ ମିଛ ପଡା ଖାଲି କହିବୁ ମୁଁ ଆପଣଙ୍କ ଅଫିସରେ ଯାଇ ବସିକି ଟାଇପ କରିଥିଲି ଆଉ ହବ होगा नहीं ବ୍ରାଉନ ସୁଗର ହବ
ଦେଇଛି ମୁଁ ଠିକ ସମୟରେ ସରେଣ୍ଡର
ଦେଇଥିଲି ଭୁଲ ଆଉ ବ୍ରାଉନ ସୁଗର
ଏବେ ତାର ବହୁତ ଦିନ କଷ୍ଟଡି ଅଛି ସେତେବେଳେ ଇନିସିଆଲ 1 year
ସିଏ ଯେତେବେଳେ ମୁଁ ବେଲ ଶୁଣୁଥିଲି ସେତେବେଳେ ଗଳି ପଶିକି ପଳେଇଥିବ ବର୍ତ୍ତମାନ ଏଇ ଛାଣି ହେଇକି ଯୋଉ ଆସୁଛି
72 ଆଉ ରିଜେକ୍ସନ ଅର୍ଡର
ବ୍ରାଉନ ସୁଗରରେ ଆଉ କିଛି କୁହନ୍ତୁ
ଆଉ ରିଜେକ୍ସନ
500 grams
532
old person 72 grams must be a veteran dealer in
ନାହିଁ କିଛି ବି ନାହିଁ କେବଳ
ନାଇଁ ଧରା ପଡିବ ବୋଲି ଆକ୍ସିଡେଣ୍ଟ ନାହିଁ
ତାକୁ ହଜୁର ବେଲ ଦେଇଛନ୍ତି one of lady and she
not seized from her person. It was seized from the present petition.
Is this matter 1 week after
Item 54.
Item 54, my lord. I want 10 days time. I will file an interim application.
Is this matter on 20th September as prayed for?
Item 55.
Item 55, may I please lordship, my lord. 20B2C NDPS Act, my lord. This petition earlier approached this honorable court and your lordship was pleased to grant 3-month bail. And this was that bail application. And in the meantime, 3 months has been completed and he has been surrendered in time, lord. Now the trial has not been progressed till yet. Only one constable has been examined, lord. Only 60 kg ganja recovered from the present petition. And he is the local man.
Yes, what is?
Lord, more than 1 year in custody. Earlier, he was released on interim bail for 3 months and he has surrendered in time. And 60 kg, my lord. Sole accused.
The petitioner is in custody since 31/7/2023 in connection with such and such case. It is alleged that the petitioner was in possession of 60 kgs of contraband ganja when he was apprehended by excise officials. It is submitted that despite submission of final despite commencement of trial, only one witness has been examined so far. And there is no possibility of the trial being concluded in the near future. Stop. It is further submitted that the petitioner is a local person and there is no likelihood of his fleeing from justice if released on bail. Then State Council has opposed the prayer for bail by submitting that the contraband was recovered from the exclusive and conscious possession of the petitioner. After considering the rival submissions and on going through the materials on record, this court finds that the petitioner's right to speedy trial is adversely affected because of slow progress of trial. He has been in custody for more than 1 year. Taking into consideration the above facts, I am inclined to allow the prayer for bail. Let the petitioner be released.
56.
Each day appearance. Total kata 58 jo acha acha.
No, please, Your Lordship. No, offence under 457, 380, 411, 413 matter. The present petitioner arise in this case as per the remand report given by the Dharmasala police. In Bhadrak rural PS case number
One
307.
accused has been granted bail. Santosh sir. Here is the story.
That 582-24 jota noting re aschi, that is different.
Wrongly noted.
So this is
498 case ta.
this is 583. 583 is the right case.
Yes.
So notice that 583 or order আছে আপনাকে.
582 of 24.
So is he the receiver of stolen property?
5 to કહું છું 411 413 is attracted.
Achhi.
Unknown
same.
affair. Unknown affair.
So we can file this, we can pass the same order?
Yes, ma'am.
All right, same order.
No 58.
57 টা কোন লাগে?
7 টা একদম উইথ ঠিক আছে।
But I am appearing on behalf of.
57 মানে 57.
Presenting the wakalat number.
Arjun.
On behalf of.
This is a dispose of case, okay.
I don't think in the
Prayer
judgment.
for modification has been filed by the petitioner being represented by Ashutosh Manti, learned counsel, who files Vakalatnama in the court. The same be kept on record. Yes.
My lord, in the judgment dated 6/8/2024, cited case number was actually WBC number 1079 of 2022, Mamata Naik. However, inadvertently it has been mentioned that
1079.
1079.
কেতে হবে সেটা?
10791.
সে গোটিকে নাও কোন আছে?
Take it.
Considering the submissions, prayer for modification is allowed. In paragraph 2, the case number mentioned as WPC number 1079 of 2022 be corrected as WPC number 10791 of 2022. Yes.
So item number 7.
None appears next week.
So item number 17.
17, yes, Mr. Rai.
The only they advertise in paper that there will be interview and all sorts of documents.
Let us come to that advertisement.
But that they have not given me.
Advertisement আপন কোন দেবে?
They not. Paper ভাগ করে ছোট পেপারটা যেটা করছেন ওটা কি মানে in order to
Advertisement for মানে engagement of
a librarian.
library
For the post library
in a college.
College.
Yes.
Library for that the petitioner, since she is a unmarried, physical handicapped, destitute lady, she applied. She has deposited her experience certificate along with other so many documents. Her experience certificate has not been considered, and for physical handicap, no marks has been given. Even though in the interview, viva test has been taken, there is no specifically no there is nothing is written that there will be viva test, and the experience holder will be given so marks, and nothing has been stated by the opposite part number 4 Miller, their college authority. But in order to give their appointment to their person Miller, the opposite part number 6, they take the interview and stated that the opposite part number 6 has been selected. When under RT Act I called for the documents, page 20 may kindly see in that the documents along with the submission of biodata by the opposite part 6. She neither has stated that experience certificate has been given in that referential, but her experience 4 marks has been given to her, for which she has been selected as first. Whereas the petitioner is the meritorious candidate among all the candidates. She is a first class student in MPhil, PhD also, and she also in the PGDCA she has scored O level marks and 17 marks career. No, except the petitioner,
nobody touched her. 17% marks she secured a career mark. Her career mark has not been considered. Rather, by giving a experience certificate sitting there, she has secured more marks in the experience certificate for which my candidates have been cancelled.
What is the name of the petitioner?
Petitioner name is Sabita Sahu. Sabita Rani Sahu.
So who was appointed? Arathi Pradhan was appointed.
Arathi Pradhan.
Arathi Pradhan secured 29.3, you secured 22.3. So what was not, what weightage of marks was not given?
49. Page 24 my kindly
Yeah, 23, I'm looking at 23.
Page 24.
24 rather.
24 Sabita serial 3, she has secured 17% career mark. 17%.
Yes, the highest.
Highest among all candidates. Her experience certificate had not been taken into consideration, rather other persons have given. In Viva test, they she secured 5.3. But in the advertisement, there is no anything stated that there will be a Viva test or the experience will be given. If that is so, then physical handicap certificate should be taken into consideration, so marks should be given to her. My case is that my physical handicap certificate may be taken into consideration, and since I am the meritorious candidate, I should be given appointment. And in the advertisement, there is nothing has been stated that there will be a Viva test. Experience and
No, but whatever. That condition was available to all candidates. You participated along with the other candidates. They never raised an objection.
I participated, but the marks will be given. They should clarify all these things, in their advertisement.
They should have, supposing they did not.
That did not mean that they should not be
No.
as per their will,
No, not their will. The same parameter was followed for all candidates.
All candidates, I don't want to say anything about that, but that should be specifically mentioned in the advertisement.
No, so what? Where is the advertisement? You are not enclosed the advertisement itself.
Yes, my lord, advertisement here.
He has not enclosed. You pass it on.
Hey, advertisement काउ दिया नहीं चुप कर
कहाँ भी देखे कौन advertisement
Second post, he is third post, my lord. It is single post, my lord. Librarian post, but his position is third, my lord. Now another person, your post is third. Another second post is 22% highest, my lord. My phone number is 29% 3, my lord. It is much less than my.
Let us see the advertisement.
Yes, thank you, my lord.
Office of the Principal, Bapuji College, Saraswati Nagar, Sandipatana. What are lecturers in physics, mathematics, geology, librarian, data interpreter, and demonstration? On contractual basis, between having requisite करने attend interview लिखा है।
Interview.
आप हमारा कुछ भाई उस पता नहीं बोली?
नहीं interview will help. तो interview को ग्राउंड कौन कौन दे जो experience certificate दे ले।
मैंने कौन सी लोग कहते हैं कौन हमें प्रश्न पूछे रिव्यू छोड़ दी थी?
No, that should be clarified.
What clarified?
नॉल मोटो फिजिकल handicap सर्टिफिकेट ताकू तो कंसीडर करा था ना
For the post of librarian, library science with computer background, all the
कुछ हेले भी एक्सपीरियंस बड़ एक मार्क 2 मार्क देखियो आता किसी फिजिकल हैंडिकैप कि अनुमान पे दो एक्सपीरियंस सर्टिफिकेट आई हैव गिवन द एक्सपीरियंस सर्टिफिकेट
so you should have challenged the advertisement. If according to you there is any case, there is actually no case, but if you wanted to, you should have challenged the advertisement. Having participated pursuant to the advertisement, how can you now turn around and challenge the advertisement? You are an unsuccessful candidate.
I have stated that I am a meritorious candidate. The merit should be given to the preference and nothing.
All right. Then, yes, what is your stand?
My lord, my stand is I am the highest secured mark, my lord. Your lordship, by test or any test, I am the highest 29% 3, but his percent 22% 3. Another person is 22.8. In Viwas, I am secured 7% and he is 5%. If 2 marks is less than means that also 29 to 25. He is more less than my lord. He is 23. He is not capable to myself, my lord. And he has not experience certificate, nothing else. But however, it is only after in 2010, my lord. I am still 2013 to today. I am running this post, my lord. No, without hindrance, my lord. But now the petitioner claimed that he is in this post, my lord.
All right. Heard in part. The part was what further arguments in part? Is this matter on 20th September? Yeah. Chedra, there will be no further argument. I have kept it because only to give time. Yes.
Merit is content should be given to class.
Chedra.
Weekly list item number 19.
There is a delay of 95 days.
Yes. AD note back from respondent number 3. Postal tracking report देखिए. Item delivered. Postal tracking report shows that the item was delivered. There is, however, no appearance. Notice was on the limitation matter.
My lord,
Yes. How many days delay?
95 days.
Who is respondent number 3?
3 is the, my lord, the lease granted in favor of the respondent number 3.
Okay. So the state is the main.
My lord.
Yes, what do you say? 95 days delay. All right. आइए कितने 120
479.
479. This is an application for condonation of delay in filing of the appeal. Office has pointed out delay of 110 days. The reasons for delayed filing have been indicated in the application under paragraph 3 to the effect that because of financial stringency, the appellants could not contact their conducting counsel in time to file the appeal. So, considering these submissions and the ground taken and the ground cited, the delay in filing of the appeal is condoned, subject to deposit of cost of rupees 500 in favor of the Odisha High Court Bar Association. Now, welfare fund. Welfare. Odisha High Court, कौन से रखो? Odisha Advocates Welfare Fund.
Advocate Welfare Fund.
Advocate Welfare Fund. The receipt be filed before this court by the next date. List this matter for admission.
Then the commence 25th October.
ଗୋଟେ amendment ଥିଲା ସେଇଟା ଆଜ୍ଞା allow ହେଇଗଲାଣି.
Amendment ଥିଲା?
ଆଜ୍ଞା ଗୋଟେ typographical error ସେ କମ୍ପ୍ୟୁଟର ଆଜ୍ଞା କଲା ବେଳକୁ ସେ ସବୁ ଚେଞ୍ଜ ହେଇଯାଇଥିଲା. By mistake mallet I have signed and filed this. By mistake mallet I have signed. Amendment ଟା ହେଲା.
What is the amendment? What is the issue?
Amendment mallet, some paragraphs mallet, wrong paragraphs. Para 2.
This will amount to completely changing the nature and character of the case.
সেটা
No. Pura completely changing the nature and character of the case, it will not be permissible, Mr. Sahu.
appeal ଟା ପଳେଇବ. ସେଇଟା our mistake, not my lord. That is my lord. I admit.
See, if there are points of law, you can raise it even without pleadings. Without pleadings. Appeal memo रे अपन लिखी ना दी बोली हबो नहीं सेमती किसी को था नहीं. IA don't press it. IA 1225 of 2023 not pressed. If it is a point of law, you can always take it. It's not a question of pleading. जहाँ pleading अच्छी तो अच्छी. ता basis रे कौन अपन argue कर परिवेन. Yes. We may frame the substantial questions of law accordingly. Yes.
So item number 34.
Amendment. No, amendment.
You need admission.
For admission.
Yes.
But the defendant number 1 and 2 are the appellants in a confirming judgment. But the respondent number 1 as plaintiff filed the suit for declaration
recovery portion along with other consequence. The suit property admittedly recorded in the name of father and mother of the present appellant number 1. The father of the present appellant number 1 was serving as a teacher. After his retirement, this property was purchased. Some portion in the name of father, some portion in the name of mother. Mother admittedly housewife. So the respondent number 2 is the daughter of is the sister of appellant number 1.
Suit was for?
Suit was for declaration of right title interest, recovery portion, and permanent injunction.
So you were defendant number?
We are defendant number 1 and 2 in the
1 and 2, yes, yes.
So the suit was filed by a purchaser who purchased, it is admittedly a homestead quad dwelling house. She purchased it from respondent number 2. Because respondent number 2 claimed that she has purchased it from the father and mother through a registered sale deed. So the moment she got it transferred in her name, we filed a suit for partition, claiming that it is joint family acquisition. And the father, during his senility, the daughter has got hold of him and obtained a document in her name. Basing upon that document, she filed a suit. The respondent number 2 filed a suit. We filed a suit seeking for partition. She was implicated as a party, so also father and mother. She independently filed a suit that I have purchased this property to declare my right title interest. That suit was dismissed. Though it was both of them were directed to be tagged together, because that is a subsequently instituted suit. But she allowed it to be dismissed after selling the property in favor of the respondent number 1 here. Respondent number 1 filed an application for intervention in the suit for partition, which is admittedly pending. And thereafter, she filed an independent suit, out of which the present appeal arises. She there claimed declaration of right title interest. We took the defense that it is a joint family acquisition. The alienation was made behind our back and without our consent. It is a joint family dwelling house. You are a stranger, you don't have any right of joint possession. And there is no delivery possession because we continue to possess the property. It is our joint family dwelling house. So this plea was negated by the Law and Trial Court, holding, Lord may kindly turn to the finding of the Law and Trial Court first. Lord may kindly turn to page 28. The paragraph started subsequently.
Yes.
So got it.
Yes.
The 4th line from that paragraph. The defendant number 1 has examined himself as DW5. The overall claim of DW5 is that the suit property lot number 1 has been purchased from the joint family nucleus, which includes his wife's salary and pension of Bhima Kesari Kora. DW5 further states that his mother had no source of income and no stridhana mentioned in lot number 1. He asserts that the suit land and building over it has been purchased out of the joint family nucleus. Accordingly claims that his father Bhima Kesari Kora and mother Malati Kora have no absolute right, title and interest over the suit land mentioned in lot number 1 property. Thereupon he opposes the transfer of the suit land mentioned in lot number 1 made by Bhima Kesari Kora and Malati Kora to Sabita Kora, the defendant number 3, which is not tenable in the eye of law because his parents had no legal necessity to transfer the suit land, the lot number 1. Further, he states that there was no passing of consideration from Sabita Kumari Kora to Bhima Kesari and Malati, as Sabita Kumari Kora had no sufficient means to purchase the suit land mentioned in lot number 1. DW5 further states
that both he and his wife were staying over the shoot land mentioned in lot number 1, but when quarrel erupt with their father and mother, they filed the partition suit bearing number 459 of 2009. The overall dispute raised by the defendant number 1 DW5 is that his sister, the defendant number 3 Sabita Korab, has committed fraud and misrepresentation and obtained the RSD dated 26/3/2010 and 3/5/2010 of the shoot land mentioned in lot number 1 from his parents. This is the plea, my lord, we have taken. Now, that has been negated on the ground that as because the father was getting pension and the property purchased in the name of mother will be her absolute property. And there is no consideration money passed the plea that cannot be sustained because we are third party to this transaction. With that conclusion, the Law and Trial Court dismissed it, ignoring that the suit filed by the for recovery of possession at the instance of Savita Kaur, the present respondent number 2, who was the defendant number 3 in the trial court, was dismissed. Therefore, the purchaser has got no locus to proceed independently, specifically when the suit for partition is pending. That has been ignored by both the court and confirmed in the appeal also. That has been confirmed. Your lordship may kindly see the reasoning is that. Well, let me admit it. Let the lordship get the substantial question of law. Yes. 3 and 4.
Yes. Heard Sri Vivekananda Bhuya, learned counsel for the appellants. Here is the impugned judgments. Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial questions of law. Page 15, 3 of 4.
Execution
issue notice to the respondents by registered post with AD, returnable within 4 weeks. Requisites be filed within 3 working days. List this matter December.
9th December.
The week commencing 9th December. Call for the LCR. IA. Notice has to go also.
Mila.
Notice as above. Further proceedings in execution case number 4 of 2023. Pending in the Court of Learned Civil Judge Senior Division Chandikhol.
Mila.
Shall remain state till the next date.
Right now 35.
My lord, on behalf of Mr. Panda, 1 week after.
Well, this is matter 1 week after I spoke.
So right now 38.
Yes.
For the appellants. Should I place?
Who's for the other side? Yes. You may begin.
For final hearing.
Yes.
I think there is a paperwork filed. Is it available with your lordship's record? All the annexures and. ଅଛି କି ଦେଖା ଟିକେ ସେଟା ଧରିଲେ ଆପଏଣ୍ଟ କରିବାକୁ ସୁବିଧା ଏମିତି ଅଛି
ଏବେ ସ୍କାନିଂ ହେଇଯାଉଛି ତ ସବୁ
ଓହୋ ଯଦି ସ୍କାନିଂ ଥିବ ମୁଁ କହିପାରିବି କିଛି ଅସୁବିଧା ନାହିଁ
I don't know. Say that is why I have to say.
ଏମିତି ଗୋଟେ annexure ନାହିଁ ଆଚ୍ଛା ହଉ lordship may kindly have a glance on the before going to the facts pleadings rival pleadings of both the parties. I want to place the case on what are the admitted facts.
Let me just see the substantial questions of law. Just for a moment, then we will go. Whether the learned appellate court could have allowed the prayer of the previously rejected by the same court in RFA, He was not challenged, whether the Appellate could have given a judgment contrary to his findings. All right.
Your lordship may see the suit filed by the people. I am a defendant. I am appealing for the defendants.
Is it confirming or reversing?
No, it is confirming more or less, but that also is there is some error of record committed by the Lord Appellate Court, which I want to submit before your lordship. What are the errors of record? I will go from the plaintiffs. Title suit number 25 of 2000. There are 5 plaintiffs and some defendants. I was appearing from the defendants.
Yes.
If your lordship will see the prayer in the plaint for declaration of right title interest, recovery of possession, and for damages. Most important is if your lordship will see what is the schedule of the plaint. The schedule of the plaint is available at page 10 of the plaint. Horobari land, house over Sabik plot number is so and so, measuring acres from 090 Dismissal of Khata number so and so. We are not concerned with the Sabik records. Your lordship may straight come to Hal record. Hal plot number 544, 35 Dismissal, 545, 10 Dismissal, 369 by 2169, 90 Dismissal. These are the 3 Hal plots in respect of which the plaintiffs have sought for declaration of right title interest and recovery of possession. Your lordship may kindly keep it in mind. Admittedly, the defendants are in possession. They sought for recovery of possession and for damages. Damages is a consequential player. Let us start. This is the suit filed by. Originally, I contested the suit. All the records were produced before the learned trial court, and the judgment was passed by the learned trial court. The first civil court, a trial court. A trial court has passed the judgment with a finding that there are 3 plots. So far as the plot number 544 and 545 is concerned, the suit was dismissed. And so far as the 3rd plot, 369 by 2160 is concerned, the suit was declared. On the basis of the fact that, as per the findings of the learned trial court, this 369 by 2169, the 3rd Hal plot, was purchased by the plaintiffs by means of a registered sale deed of 1957, that is Exhibit 7. That was the finding of fact. And suit was partly decreed. In respect of 1 plot, it was decreed. In respect of 2 other Hal plots, the suit was dismissed on the ground that that is government plot. So we are not going to that aspect right now. Against that judgment, which was partly decreed by the trial court, 2 appeals were preferred. I preferred appeal number, RFA number 9 of 2004, and the plaintiffs who could not get a favorable decree in respect of other 2 plots. Am I clear, Your Lordship?
Yes.
They preferred RFA number 16 of 2000. Both the appeals were heard by the additional district judge Raurkela, same appellate court, the first appellate court, and both the judgments were disposed of on one day, not a common judgment, separate judgment. My appeal was dismissed, their appeal was dismissed. I'm sorry, my appeal was dismissed and it was remanded to the court below. That is not an open remand under Order 41 Rule 25. The appellate court framed 2 issues and directed the trial court to adjudicate those issues and pass final order. We are also not with that. So far as the appeal preferred by the other side, that is the plaintiff, who could not get a favorable decree from the civil trial court with regard to other 2 plots, that appeal was dismissed on contest. So what I beg to submit before going to argue the matter on merit, Your Lordship may kindly keep it in mind that the suit was initially, the findings were initially against him so far as these 2 plots are concerned, that he has no right title interest over it, and he is not, they are not entitled for a decree for recovery of possession. No title was declared in their favor so far as those 2 plots are concerned, 544 and 45 by the trial court. That judgment was tested by the first appellate court and first appellate court confirming. These are the admitted facts. And further admitted fact, Your Lordship will find that first appellate court judgment, which was against him in RFA number 16 of 2004, that was not challenged in our second appeal. So before going to the merit of the case, I want to impress Your Lordship that so far as that finding is concerned, that reached its finality. So they have no right title interest over these 2 plots, and they cannot ask for any recovery of possession of my clients from those two plots. Then what I already submitted before your lordship, so far as my appeal is concerned, that was remanded by framing, the appellate court has framed two issues, and again it was placed before the learned trial. Learned trial court reiterated the same judgment. That was again challenged by me in another act. That he said that no, so far as that plot is concerned, they have purchased it in Exhibit 7, so they are entitled to get a decree. And that judgment, the second time jo judgment dele trial court, ta against mu appeal kali RFA number 8/2007.
Mr. Mahathi, you will have to prepare a tabular, this will be confusing. Paper book ta to nahi ho kale kono.
Paper book ta mu dei.
Fact clarify ଟିକେ କରିଦେବେ।
नहीं करो जे आपण जहाँ करूँ you must find out, you must file है नहीं सुन, you must file है compare tabular, you file it in a tabular form so that it will be easier. Which suit, which appeals. Because again demanded, again another
issue nahi. Absolutely that
issue nahi sir. More gottiev only point that once a judgment and decree is confirmed by the appellate court, whether that can be
that is also the substantial question of law.
That can be reopened by the same appellate court in a subsequent proceeding.
Say kathati khali mutti subject to Mr. Mahathi.
I think we'll take it up. Just keep it as. I'm asking you, my memory goes back only for 5 years, not beyond that. I don't remember that. I'm just asking for my clarification. ବର୍ତ୍ତମାନ ପୁଣି କହିଲେ
He is the busiest lawyer of this.
No, no, ଆଜ୍ଞା ସିଆଡେ ବି ଯାଆନ୍ତୁନି। ସିଆଡେ ବି ଯାଆନ୍ତୁନି। ଆପଣ ଯୋଉ କହିଲେ ବର୍ତ୍ତମାନ ବୋଲି but now why you have to give a clarification now କଣ?
Nowadays.
डायरी टा आपन पाखरे हाजर करितले आपन जान देबे सेतिर डायरी तो चैम्बर I also belong to the same chamber.
Yes. That I know. Yes. 23rd September. So it will be item number 2. It will be item number 2 because another part has come, so it will be. Yes, that will be easier. Otherwise, no. You relate because there will be different numbers. There will be different numbers now. Only for that, I am not saying anything on merit. For this. Lucky though.
46,
I am for the respondent.
Yes. Yes, Mr. Mishra.
I was praying for next week.
Okay, next week. 23rd September.
My lord, there was the interim order. May kindly be extended, my lord.
Yes, interim order to continue.
Obliged.
So I don't know 48.
Yes.
My friend is saying that LCR soft copy.
Government counsel for the appellant is permitted to take soft copy of the LCR on a pen drive. Is this matter in the week commencing? 30th September.
Interim order is there.
Interim order to continue.
So I don't know 49.
In both the appeals, I am for the respondents. One appeal is a confirming judgment, other one is the counterclaim was dismissed by the trial court. It was allowed by the first appellate court. Therefore, the plaintiff has filed 2 appeals, separate appeals. And the common question of law that is admitted.
Who's for the appellant?
Appellant not appearing so many days. Your Lordship, even yesterday, day before yesterday, not appearing.
You are appearing for the trust.
Yes, I am appearing for the trust.
None appears for the appellant on repeated calls. This matter being in the weekly list was called out on every day from 2nd September. General counsel for the respondent was present on all dates. But there was no appearance from the side of the appellant. In the previous week also, In the previous weeks also, there was no appearance from the side of the appellant. As such, it is presumed that the appellant is no longer interested to pursue the appeal, which is therefore dismissed for non-prosecution.
Both the.
Yeah, same order to have. Yeah, I knew you are, I remember you were pressing for dismissal, but second appeal.
Again, Kali upon the call.
Chance देगी. Always before Mr. Jana, before taking a drastic step, the court should always, this is my view, old fashioned view, but dismiss करते हैं, सांग dismiss करते हैं, कैसा लगेगा? Yes.
Second offer.
Second appeal दी ना second appeal dismiss. आया फिर कोई उन्हीं लोगों को ना बस्ती ना.
So I don't know 50.
Both sides are here.
Mr. Rautre?
Yes. But a soft copy and question is not that soft, which is involved here. Because your lordship may kindly appreciate that we all know about section 53A. Whether it is to be sealed or sold. Some judgments are there that if the person.
It can only be a shield, it can never be a sword.
That it can only be a shield, but whether it is a shield for the plaintiff, because shield can never
Only be by the
only for
defendant.
That is what will be the question of law to be determined here. So that is the reason I will be taking a soft copy. You'll also may keep it to.
Yes, sir. Sir, what do you say?
All right. I have absolutely no objection, but my learned friend is, let's suggest that which date will be convenient to him. So that matter can be solved. That is the only.
The week commencing 30th?
30.
Hard in part, and also keep it to 30.
If you agree, sir, I'll keep it hard in part.
Yes.
Hard in part, is this matter? See, you week recollect the third item.
I said that there is a data option.
This is the we'll keep it on 30th.
30th.
It will come as item number 1.
Yes.
Yes. A soft copy.
Both counsel for both sides are permitted to take soft copy of the LCR on a pen drive.
Interim order to continue.
Interim order to continue.